Yes.
Not let's say one thing. One which cannot be done directly. There cannot be any debate on this proposition of law. Should not be allowed to be done indirectly. But this is one of such class of case.
Yeah, one second.
I'm sorry.
Yes.
What has happened, Lord? The private respondent hearing are the repetitioners. They sought for implementation of certain orders passed by the revenue officials. One has its color under regulation 202, one has its color under regulation 104. This is fact. The writ court directed implementation of one of the order dated 9 July 2024, which is under regulation 104. Now, this is based on record. My first phase of argument would be the private respondents hearing in an attempt to get a part to their own landed property in past failed. They approached the revenue officials by making representations, failed, report adverse, even tenders were floated to have path from to their home because they have another path. When they found that nothing was yielded, they resorted to steps. They approached the revenue officials. They got an order from the deputy commissioner way back in the year 2011. I was not given a notice. The deputy commissioner from my recorded property carved out a portion, holding it to be a government revenue land under survey number 120, and it has been held that it's for public utility. I'll show those papers. When it was not given effect to lordship, proceedings were initiated before the concerned Tahsildar. That's Tahsildar Private. Tahsildar passes fjords. I showed all these orders. None of these orders direct my client for eviction. Despite that, a writ was filed by the private respondent hearing seeking implementation rather than orders standing in the face of the private respondent. I'll show that. Certain interim protection was granted during the pendency of the writ petition, directing both my client as well as the client of Mrs. Nath not to carry out any work because this has been alleged by the Nath's client so that I am carrying out certain work.
Now, who passed the eviction order? Deputy Commissioner.
Tahsildar passed under regulation 202. Now, Tahsildar on a particular date, that's 9 July 2024, passes two orders in a two different proceedings. And both the orders carry the same survey numbers. So far as order dated 9 July 2024 in RC number 592 of 2024 is concerned, Lordship, that is under regulation 202 against which a suit was filed. A competent civil court in seizing of the matter have stayed the operation till disposal. Appeal filed before the district judge. It was taken up yesterday for the first date. I filed my Okalatama. It's coming up in the month of June. This fact was brought to the notice of the victim.
But that eviction, that 202 was pertaining to a particular plot of land.
That implementation of an order was passed. It has the same color. I'll show that. There is no changing color, no.
Now, the eviction order has been passed under which provision?
104 they claims and the report has directed for that. But that 104 order carries the same date, 9 July 2024. But in an RC number 593. So for us 202 order, same property 592.
Same property.
Yeah, I'll show that. I'll show that.
And what was the land involved? Land involved was not.
Yeah, show that.
So two eviction proceedings are going on in a different forum.
But before the same forum, two eviction orders. So for us first eviction order, I have obtained a stay from a civil court. Same order is found in different RT case number 593. If they sought for implementation, the report passed the order for implementation. This fact was brought to the notice that civil suit is made.
So you are that writ petition order is under challenge.
That the order which has been passed is under challenge in this intra-court appeal. Let me take note of a few papers. So far as eviction orders are concerned, now kindly take up my CAD stay application. Every papers have been enforced.
So, Mr. Jaipal, if your order of eviction, which has been sought to be implemented through the writ petition by the private respondent, it has been categorically stated that that order is not the subject matter of challenge in this suit.
Not.
This is, so,
Say one thing, Lord.
no, you please show us that the eviction order as well as the order under 202 are pertaining to the same law.
Can you turn to page 88 once of the stay application? 88. This is the order which the report has directed for implementation by order in June, page 88. Page 88. I'll just read this one page order, which is purportedly issued by Tahsildar Fragrance in exercise of power under regulation 104. I'll show this. Now, the very important point would be at the top at page 88, revenue case number may kindly be taken care of.
590.
RC number 593/2024. I'm just placing this order. Eviction order, whereas white PMO PG/TG/24/0066/414 filed by one Sri Bhajan Lal, residents of Batubarsi Porter regarding civic amenities and infrastructure, resisted water, power, communication, internet, road, public infrastructure rights, public entitlements / pensions, salary, promotion, job benefits under various schemes. And whereas this is the detail of the land. As per the report of the revenue field staff, the land bearing survey number 120, area 1178 square meter situated at Dhanikari village under Fragrance, and land bearing survey number 1/20, area 675 square meter situated at Humphrey village under Fragrance has been set apart for construction of rural road at Dhanikari and African village by DC's SA order number 542 dated 10/6/2011. And whereas the report further reveals that the administration issued notification number so dated 27/2011 Fragrance Asset has been declared as local area under the provisions of section 48(1) of Andaman and Nicobar Island LR and LR 1966 and revenue survey of Dhanikari village of Fragrance Asset for Andaman. And whereas during the revenue survey, it is noticed that set aparted land have been shifted without the consent of opposition for the party.
No, whereas during revenue survey, it is noticed that the government land bearing
page 88, no? Page not kindly come to page 88. 88.
Oh, sorry. I was seeing that.
I'll place again, Lord. I'll place again from top.
That is same as page 89.
No. That's under regulation 202. That's under regulation 202, page 89.
Is under 202.
202. Page 88. Say, I'll come to that. Page 88 under regulation 102. But can you see paragraph 2 of page 88? And whereas, as per the report of the revenue field staff, that the land bearing survey number 120, 1/20, area 1178 square meter, situated at Dhanikari village under Fragrance, and land bearing survey number 1/20, area 675 square meter, situated at Humphrey village under Fragrance has been set apart for.
What is SY number?
Survey. SY means survey.
So the survey number under this survey, this is a plot.
It's a plot.
Now, how is the survey?
Plot would be a land which is within the urban area. If the land falls within rural, it would carry a survey number. It can't be plot.
I see.
That's the difference.
I see.
Survey number of plot has been defined.
So the survey number 1 comprises of land under Dhanikari village
and African village.
Both
separate. Carrying a different area. Not paragraph 3.
Yes.
And report further reveals that the administration issued notification number so dated 27/2011. Fragrance Asset has been declared as local area under the provisions of section 48 of bracket 1 of Andaman Nicobar LR and LR 1966 and revenue survey of Dhanikari village of Fragrance Asset South Andaman. And whereas during the revenue survey, it is noticed that the set aparted land has been shifted without the consent of opportunity for the parties. And whereas that is said unauthorized occupation of government park need to be vacated forthwith in pursuance of section 104 of the Andaman and Nicobar Islands Land Revenue and Land Reform Regulation 1966. Now therefore, the revenue inspector number 4 is hereby authorized execute eviction order number eviction on 13/7/2024 at 10:30 AM and report compliance given under my hand and seal of this court on 9 July 2024. Now I would see from these pages, nowhere it is found that this order was against my client. Rather, Lord, can you see at the bottom, serial number 7, it's addressed to Bhajanla. If this eviction order is taken as a sacrosanct, then that would be against Bhajanla, who was a writ petitioner before the court, who was sought for implementation. Now, this is the order under regulation 104. I'll show the same.
Now, what does this para mean? Whereas the revenue survey, it is noticed that the set aparted land have been shifted without the consent of
Even I
opportunity.
could not understand between these lines. Even I could not understand between these lines.
But this order is passed pursuant to any earlier writ code.
There was no interest.
There was simply a complaint on the part of the private
I
respondent.
was seeking interest in interest. He specifically mentioned in the presentation that the land which he wants as payment is going through my land property. So we both are adjacent properties.
So what is your case? You are,
My order, eviction order, I'll show that. So kindly turns to page 125 of the stay application. 125 of the stay application, which has been stayed by a civil court for the same property. Page 125.
what is the date of the order?
9 July 2024, but the different revenue numbers here at the top. Not NEC page 125 at the top. It's RC number 592. The one which I have read just now is RC 593. So my proceeding was the past one. I'll raise this order. The order which is under challenge before civil court is this order.
This, by virtue of this order, they were sought to be removed.
Absolutely not. Not what saying.
Acha, let us see.
Paper speaks, please, sir. I may lie, not what the documents may not.
How can Jaipal say he's not a tehsildar? Yes.
Look, can you see? I'll just read this on page 125. Whereas, same lordship, find again paragraph 1, 2, right from paragraph 2. And whereas, as per the report of the revenue field staff, that the land gaining survey number 1 of the 20, same area measurement is same, 1100 square meters situated at Dhanikari village, under fragments. And land gaining survey number 120, area 675 square meters, situated at African village, under fragment as set apart for
This is under regulation 202.
202. What I did, I understood. This order was stayed by a civil court, I'll show that. Same nature of order is same thing.
So what is the difference, tell us, between 104 and 202?
The only difference was to find third paragraph. 125 third paragraph is missing from page the first 88. Third paragraph with regard to survey number 1 of the 3, which is recorded in my name. I'll show the recorded.
Wait, third paragraph name?
Page 125 and there is doing revenue survey. Page 125.
Yes.
Fourth paragraph, sorry, fourth paragraph. And whereas during revenue survey, it is noticed that the government land bearing survey number 1 of the 3 area 2.40 acres situated at Dhanikari. And whereas said another occupation need to be removed totally in pursuance to section 202 of Andaman and Nicobar Island, LRR 1965, and some same date was given.
So both the orders were passed on the same date?
Same day, but with different revenue cases. And both the orders are against Bhajanla. At page 125, you have to see, same, it is addressed to Bhajanla. Nowhere my name has been recorded as Ritesh Lal, who is the appellant before this court now. Now this additional one paragraph at page 125.
No, this to page 88 and 125 pertains to eviction from which plot of land?
That's what these orders is not clear. To whom it would direct, it's not clear.
No, both the orders had been at the instance of a representation made by Bhajanlal for seeking civil amenities.
No, but that's my time for eviction also. That's because I'm not given a notice.
So very good, then why you are challenging me?
My property, because I'll show the map. The property of mine and the private restaurant's property.
Now, whether this eviction has been implemented?
It's so much.
Acha, chale.
It's already improved.
My compliance.
Yes. Sometimes status quo. I will photograph the police persons are there.
The merit of the matter.
No, just because yesterday it was said that it has been implemented.
Compliance.
So very good. The 202 and 102 orders are pertaining to the same thing. And that both the orders have been passed at the instance of the private respondent.
But not my point of argument.
No, this is understood. Next, what is your contest? So please show us 104 and 202. What is the
And they
difference?
have a
Different.
Now I'll take you down. Yeah. You are showing us the regulation.
Regulation, first part of the book, no?
Page 20, Milan.
Let me take you take the premises. Fine, please. Please,
Why you are disturbing Mr. Jaipal? He's already under pressure.
I'm only the brief of my client. I need to praise every
His
time.
anxiety should be appreciated.
It's not an anxiety making argument.
No, that is why I tell my learned advocates that don't, in our principal bench, you know, the new SESP centenary building has come up. So that is, you have to cross the main building, the centenary building, and go to the SESP center. So suppose 654, a matter is going on in SESP centenary. And I sitting in court number 11 in main court have also called the matter. It is almost, the advocates, they run for their life. So I tell them that don't run, take your seat, get back your breath, and then make arguments. See, it's the, we understand the tension of the advocates. Yes, 102,
Now, kindly turns to page
33.
page 20 of the regulation. First part of the book, page 20, or to find at the left hand side of the book, page 20. 66 regulation.
No, this is I'm looking into 68 rules.
No, regulation 66, regulation is not.
Regulation.
It's there, Lord. Regulation is one book only.
Oh,
One book only.
so first page 20.
And left hand side, page 20.
Yes.
Not to see at the top, 104,
So this is a provision under the
regulation 66.
regulation 66.
And
It's a rule 60. Yes.
Not to see if the consider finds that may any obstacles impedes the free use of a recognized road,
Oh.
path and common land of the village. He may order the person responsible for such obstacle to remove it. And if such person fails to comply with the order, may cause the obstacles to be removed and may recover from such persons the cost of removal thereof. Now, there are two things. If a person occupy a path, road, then in exercise of this power, Tahsildar, on making an inquiry, can pass an order. Now, the order, if I go with what the other side said, not the order of eviction under regulation 104, nowhere directs my client for eviction, but my property has been.
A person who is occupying this.
That's right.
You nowhere directs you. If you are in possession, you will.
My property has been damaged now. Just only photographs I can bring this.
So it is an admitted fact you were occupying that portion pertaining to 104 order. Then it is admitted. Now you tell us the flip side 202 how you are saying.
Reference to page. This regulation 202 at page 14 of the same book, regulation 1966. You could come on at the left hand side of the page 40.
This 202 is under the rules
Regulation.
or both are regulations.
What is that page 14? Well, I'm just reading 202. Any person who unauthorizedly takes or remains in possession of any unoccupied land or abadi may be summarily ejected by the order of Tahsildar. Any crops which may be standing on the land in any building or other works which may have constructed thereon, if not reviewed by him within such time as the Tahsildar may fix, shall liable to forfeiture. 2. Any property forfeited under subsection 1 shall be disposed of in such a manner as the Tahsildar may direct, and the cost of removal of any crop, building or other works, and all works necessary to restore the land to its original condition shall be recoverable from such person as an area of land revenue. Such person, subject to the provisions of subsection 5 also be liable at the discretion of Tahsildar to a fine which may extend to 250 rupees. The Tahsildar may apply the whole or any part of the fine imposed under subsection B to compensate person who may in his opinion have suffered loss or injury from such unauthorized occupation. If in any case the Tahsildar considers that the circumstances of the cases warrants imposition of fine exceeding 250 rupees, he may refer the case to the sub-division officer, who shall then, after giving the party concerned an opportunity to be heard, pass such order in respect of fine as he may deem fit. Sixth word. If any person's order to be ejected under subsection 1 has constructed any work of permanent nature under a bona fide mistake, he may apply to the Deputy Commissioner for condonation of encroachment, and the Deputy Commissioner may, if satisfied that work was constructed under bona fide mistake and that the land can be allowed to remain in the possession of such persons without any serious detrimental to public purpose, condone the encroachment under such term as he may deem fit. But these are two crucial provisions. Seventh, no order made under subsection 1 shall prevent any person from establishing his right in a civil court. Then 8 comes into play now. It says, if notice of intention to institute a suit is delivered to the Tahsildar, he shall desist from carrying out his order under subsection 1 for a period of 3 months. And if such suit is filed within such period, he shall stay his proceeding pending the decision of the civil court. Now, as against page 122, the one order which has been passed under regulation 202 for the same property, suit has been filed before the joint senior division, and interim protection is operating till disposal of the suit. That order has been stayed. I'll show that order by the joint senior division.
Then very good, your protection, you are protected. Now this eviction order, according to you, since you got the protection, you are then admitting that you are in unauthorized occupation, you come under 102.
If that be the case, the writ court do not have past implementation. My point of argument is, Lordship, when this fact was brought, not have noted my argument as regards the pendency, but not have held that order in RC number 593, which carries the same date, is not challenged. But both the orders have same color, same color.
You did not challenge which order? Page 88 order?
It have not been challenged. The report said that because it has not been challenged, it needs to be implemented. Let's go with the situation also, what the report has said.
No, what is the difference between 88 and 125? No. 125 order which you showed, page 120. That is also an order under 104.
No, 125 is under 202, page 125.
Oh, this is under.
It carries two survey numbers, not 125 carries two survey numbers. Second paragraph is one survey number, 120. The second survey number is paragraph 4, survey number 1 of the 3, which is recorded in my name. I'll show that papers also.
Both the survey.
And 18, I'll show that. No one will not do that. No one will not do it. Making submission based on record.
Proposition has been filed, totally different.
How I show
I have shown proposition, I have shown your worship how things have been played by him.
Well, page 125 pertains to two survey numbers, 1 by 20 and 1 by 3.
Absolutely.
And the page 88 pertains to
1 by 20. Same area, same village.
1 by 20 and not 1 by 3.
1 by 3 is in my name. I'll show that.
It's a government land.
He will not say, no, the act of coming not show them. Having already, it's 1 of the 3. Also, what kindly comes to the land record, which is a part of an opposition.
And kindly see the measurement.
Please, I don't let me finish first.
1 by 20 is 1 by 20. You are occupying, you are in recorded in your name, that is 1 by 3. This is recorded in what is your name?
It's a Ritesh.
Ritesh name.
You want to see page 108 of the
Ritesh.
page 108.
No, very good. Now this page 88 is directing eviction from which survey number?
Second paragraph.
Page 88 does not refer to 1 by 3.
Yes, it's silent. It's silent.
So very good. Then the 1 by 3 comes within your proceeding, in which page 125 order was passed.
The cost of reputation, page 120, 125 mechanical again, at the cost of reputation, paragraph 2 and 4 paragraph.
So that is same in page 188, 1 by 3 is not there.
That's the difference. The other difference is invocation of 104 and 202. This is the second difference in both the orders. And third difference is RC number, revenue case. So far as my order, which I've shown is that RC number 592.
So then 1/3 pertaining to that, page 125 order has been passed
Yeah.
for eviction.
Orders, no. Both the survey numbers, not kindly see page 125. It no, not kindly see page 125 paragraph 2.
Yes,
Not kindly see.
1/20 and 1/3.
Yes, 3.
And 1/3 you claim to be the recorded owner.
Yes, I'll show 108.
So this eviction, this eviction order was passed also at the instance of Bhajan Lal.
Yes.
So this has been stayed.
This is the act of collusion. The revenue officials are handing down with the private respondent. That is specific case I have made up in the writ petition in my opposition.
Pending decision of civil court.
Pending decision also.
Well, I saw the civil court order once.
This order is restricted to only.
Bhajan is the occupier of 120, Sabi 120.
No, order says so. Order, because no one, that's my time, Mutation.
It's copied.
Both the order, no, this can't be.
It's copied.
I think it has to be my hand, other Bhajan.
Then I will.
What is the name of the father of Riteshla?
Kanayala. But I can understand. If the order of eviction is staring in my face, implementation has been sought for, I can understand. Nowhere my order names are
I
recorded.
don't think 1/3 is in his name
1/3 measuring 1.20.
only.
Only 1.20.
1.20.
Yes.
1.
There is a difference. I'll explain you.
And 1/3 race portion is
Government land. Government. It's a government land. That portion is a government land, but
is there any demarcation?
yes, Your Lordship, it's very clear. Let him complete, Your Lordship, then I will clarify the things.
Yes.
So if your contention, if we have understood is page 88 order pertains to a survey number 1/20,
Yes.
which is not being,
Subject matter of the suit.
which is not being, who is occupying it? 1/20, you are not there.
Kindly
Please,
appreciate what they are doing now. I show the map.
No, Mr. Gopal, 1/20, are you claiming to be in occupation of 1/20?
How is that?
It's not existent. What they do, no.
So 1/20, you say you are in possession.
It's existent to a recorded line of 1/3. So 202 has been removed.
Excess land means under which legal concept? Excess land.
It is island. Enclosures are not alien. They occupy, there are schemes for regularization. Time to time, government launches schemes.
So
for regularization.
anybody can encroach.
Yes, but there are certain conditions.
Legal right of encroachment.
Conditional fulfillment of conditions are there, not under the scheme. Who fulfills, they get the regularization.
Very good. Yes, anything else?
My point of argument is, you kindly appreciate one thing. I'll just show the civil courts order at page 144 of the stay application. And these two survey numbers were considered by a civil court, page 144. Now, see, I'm just reading this page 144 up to page 147. I mean, by the joint civil judge, Seniority court there. And I'll show my claim also here. What made my client to file suit is based on 125. RC case 590.
No, your case is, you tell us your case 1/20, you are in possession.
Yes, along with my record.
So this order prejudices you, because by this eviction order, you will be thrown away of 1/20.
Only 1/3 also.
Why 1/3? This order, we will say it will restrict it to 1/20.
Yes. Now, kindly appreciate one thing. If they want to remove me from 1/20 in terms of regulation 104, appropriate demarcation in my presence, nothing was given, bro. That's my case.
No, Mr. Jaipal,
Bro, kindly appreciate.
you cannot eat both sides of the cake. Huh? You 1/20, you are saying that you are in possession, this eviction order is affecting you, ask the writ court to stay.
Hello.
This was your one prayer. So, and the other fraction is 1/3 survey, you are the recorded owner.
Yes.
202 step has been taken. Only difference between them is 202 and 104. 104 is unauthorized occupation to be removed, and 202 is penalty for unauthorized occupation. then there wouldn't have been two provisions, Mr. Jaipal. 104 is removal of obstruction.
104 comes into play if a person is found occupying a road path, that's all.
Exactly.
If a person occupies government revenue land in exclusion of path,
That right has not crystallized in your favor. No. The excess land which you are saying, that is an unregularized excess land according to you. So government has every authority to remove
My
it.
point of argument is,
No,
when
no.
the civil code have stayed the order.
That is pertaining to that is pertaining to the land. Page 125, you have yourself said that it is restricted to page 125 refers to 1/20 also.
Yes, that's what I'm doing. That's my point of argument.
As well.
My point of argument is.
And in the page 88 also, only is it restricted to 1/20.
Only one. That's the number is not there.
But this is a game being played by no game. So how this has been.
It's not a game.
It's an absolute game. It's an absolute.
Now, what is the status of that? What is this? Have you constructed any building over there?
I have raised bundles, fencing or kinds of photographs as of now. Police persons are there. Everything is in marketing basis. I can bring this document on the
It's not there.
It's a post-it fact. I can bring it.
It has already been implemented.
No way.
Yes.
Saying will not do harm.
It's not saying the date is not there.
Page 88 order
So guys, more concern.
Now, page 88 does not refer to 1/3.
No.
1/3 नहीं बन.
1/3 is not there. It's only with regard to the path.
But Prashu, 125 carries both the seven number. This is the same civil code. Then there is no objection to get implementation of the subsequent order.
Yeah. You are saying that the 1/20 and 1/3 are both contained in the 202 order,
Yes.
in respect of which you have obtained a stay. Now, what you want to show us from which stay order?
Page 140. By joint civilian citizens of the sector. Can I see? It's an order dated 5/2/2000, page 144. I'm just placing this order. These two survey number was considered by was lacking injunction.
No, show us the operative portion.
Operating portion kindly turns to page 146. Ordering portion. The application data on the plaintiff. Application dated 12/7/2024 filed by the plaintiff under order 39 rule 1 and 2 of the CB is allowed on contest but without any order as to cause. The order of eviction dated 9 July 2024 passed by the Tosula Parliament. White TFG RC number 590.
That is page 125.
Under section 202 is stayed from its operation till disposal of the suit.
So very good. So page 125 is a 20 is an order directing eviction.
Of both the survey numbers.
No, 1/3 only. That is what is That is what has been argued also before the Learned Single Bench.
What anything you want to show us from? No, what you wanted to show us from the order at page 144? That both of them are involved.
This was considered by civil code. Page 144, number finally comes to page 144. I'll place this.
Is the citizens of
So see, both survey numbers now to fill second paragraph. I'm just reading this. Not time is not allow me to read this to you. The learned advocate for the plaintiff submitted the plaintiff's father, Kanhala, had encroached upon a government revenue land in survey number 1/3, measuring 2.40 hectares situated Thondikari village under Fragment Tahsil. The suit was subsequently adopted in the name of said father of the plaintiff, only to the extent of 1.20 hectares out of 2.40 hectares in survey number 1/3. After death of father of the plaintiff, the suit land is now recorded in the name of plaintiff and his brothers and sisters in the government revenue records of right, as mentioned in the office of Tahsildar. The defendant number 1 hearing, without any authority and in order to grab the suit land together with the excess land, he is trying to dispossess the plaintiff from the suit land. The defendant number 1 in the past made several complaints against the plaintiff before the higher revenue officials, which was with a view to disturb possession of plaintiff or suit land without any authority. On 9 July 2024, the pro forma defendant issued Eviction Tahsildar in connection with the suit land, but very interestingly, the copy of such eviction order was not addressed to the plaintiff, wherein rather is given to the defendant number 1 of the present suit. There is an extreme urgency to move and file the present suit, as the eviction order dated 9 July 2024 in TFG RC number 592 of 2024 under provision of section 2021 of the Andaman and Nicobar Islands Land Levy and Land Reforms Regulation 1966, the rule strain thereunder has been issued by the pro forma defendant to aid the plaintiff from the suit on 14/7/2024 at the instance of defendant number 1. On the other hand, the learned advocate for the defendant number 1 submits that suit is barred by limitation. Suit also suffers from non-gender necessary party as the other legal Kannada has not been made party to the case. The defendant number 1 is concerned about land bearing survey number 1 of the 20, measuring 1178 square meter.
They are not concerned with 1/20. They are concerned with 1/3.
This was considered by the court by granting the entire state, which comprised of both the survey numbers. Consideration was made by civil court. Then the Tahsildar order of eviction.
No. Now on next page, now on perusal of document, page 145,
45.
last paragraph. Now on perusal of.
So the documents and very.
Now you read the previous pro forma defendant submitted in 120 over 1178, which is set apart as a rural road, was under your occupation, forcible occupation. Now the operative part where it is said that this order will be also in respect of 1/20.
Because the order of the Tahsildar has been stated, no, that's the point.
That is 202 order at page 120.
Order comprises of both the survey numbers. That is my point of argument. It does not indicate only one of the 3. It includes one of the 20. But again, I am doing 202 order again. The entire order, not in isolation, order, the entire order of state. When it has been stated, there was no occasion for the Tahsildar to pass 104 order. By evidence, both the survey numbers have been stated. They have filed an appeal before the district judge. My point of argument, can you appreciate?
Who has filed an appeal?
The other side have filed an appeal against this order of the joint civil justice division. They filed an appeal.
Oh, there for vacation of the interim order.
Yes, it was fixed yesterday.
In respect to that particular order,
But the
153.
But kindly appreciate, first of all, but kindly appreciate one thing. Even the order under 104, nowhere directs my plan for eviction, this one part. 202 order comprised of both the survey numbers. And this order as a whole was stayed by civil court under regulation 2028. If that be the case, Rashid, it's my humble submission with due respect, the writ court ought not to pass implementation. Particularly when a civil court is seizing of the matter, this matter needs to be carried out. No, if they could succeed in appeal.
All right. Anything else,
This
Mr.
is my prayer, but I will show one few things as regards I'm the recorded tenant of land. I'll just show that.
That is 1/3.
I show the recorded.
No,
No, that is admitted.
It's not a case that I'm an exporter and poacher.
Admitting.
One 145 the very last paragraph takes it down. Now on perusal of documents.
Considered by the children. One of the 20, one of the.
Where is the single judge, where is the? Yeah, anything else, Mr. Bajaj?
The confinement submission to this are great. So can be expedited, but the implementation, because it's in full swing, even as of now, it's undertaken.
Yes.
I claim that for staying the order of the single judge and also the eviction order, is the single process that for implementation.
Yes.
Your worship, kindly come to page number.
You are appearing for bhajan.
Yes, yes. Because this particular one of the 20, that is the recognized path which leads to my land and also the land of certain other villages. This particular 1/20. Now, your worship may kindly come to the first document I would like to show is the order of the deputy commissioner whereby land was set apart.
Tenth of June 2011, order.
Yes, yes.
That is page 69.
Page 69.
16. So you worship may kindly see here. The survey number is mentioned. The measurement is also mentioned.
Where is the survey?
1/20. And measurement is also mentioned.
Measurement is
1178 square meters.
Area.
Dhanikari, because it is dividing, it is between two villages.
Yes.
The Dhanikari 1/20, 1178 square meters and 1/20, 67 square meters. Now, we should be kindly see here. I just want to differentiate that one. Kindly come to the proceedings. Whereby this 1/20
starts from page 72. Starts from page 72. The proceedings.
You know,
RC proceedings.
yes, RC proceeding. RC proceeding was initiated in order to locate that particular path. Page number 73, your lordship may kindly know. 73.
Yes.
Now kindly see here, there is survey number 1. Bottom your lordship, village Dhanikari survey number 1.
Yes.
The survey number of this particular landed property, out of which the path was constructed, because it was a government land. Survey number 1 was a government land. Now, the authorities have decided to have a path which would lead to the lands of the villages. So 1/20 was carved out. There was no objection. He has not filed any objection with regard to that. He has not agitated this issue. Now, your lordship, thereafter, it was found. We have, when the authorities came on spot, they found that he is in occupation of survey number 1 of the 20. So an eviction order was passed after a proceeding. An eviction order was passed. There has been no, in the affidavit in opposition, now at any point of time, he never said that no notice was issued to him and no hearing was given to him. That was not at all his case. He has not challenged the order of 9 July 2024 at any point of time. I filed the writ application for implementation of that order, your lordship. It is not his writ petition that he has challenged 9 July 2024 order. He never challenged. No. As per regulation 20.
Now he is challenging.
No. Before the revision mentioned.
No, before Justice Sen, in the writ petition.
He never filed the petition.
This writ petition was yours. 9 July 593 proceedings, 125.
For implementation, I came before this honorable court. And this honorable court, he never challenged before the, as per the regulation 28, there is a provision of appeal. He came to know about that order when I filed the writ application.
Regulation
28. Provision of appeal is there.
against which order? Under 104 order.
Yes.
Any order of tehsil.
Tehsil is applicable for subdivision office.
Yes.
Now, when he filed the writ application, let us assume, for argument's sake, that he had no knowledge about 9 July order. Let us assume. But when I filed the writ application for implementation of that order, he came to know about that order. Why he did not challenge it? Neither he challenged before the subdivision officer by way of an appeal, nor before this honorable court by filing the writ application. Both the things has not been done. What he did, he filed a civil suit. And in the civil suit, the schedule of property may be seen. What is there? It is not one of the 20.
Huh? Where is that
Schedule of
schedule?
property may be seen. Page number 140. Page number 140.
Hmm.
Schedule of property may be seen.
Government record.
Government revenue land in survey number 1/3, measuring 2.40 hectares.
Hmm.
He just increased the measurement of the land very cleverly. Whereas he is the recorded tenant of 1/3, measuring 1.20. He knows that. Then why did he describe that particular 1/3 as government land? Your Lordship can very well understand what was the reason behind it. When he knows that he is the recorded tenant of survey number 1/3, measuring 1.20 hectares, page number 125, I think. 108. 100. 108. 108 clearly specifies
1/3.
that he is the recorded tenant of survey number 1/3, measuring 1.20 hectares.
But in the schedule of property.
In the schedule of property, very cleverly, 1/3.
No, page 108, what did you say?
It's
He is the recorded tenant.
survey
He is the
number
owner of the property, 1/3.
record of rights.
It is a record of rights. We are not disputing it. He is the owner.
No, he is Ritesh Lal.
Yes.
So he is 1/3,
One-
area 1.2 hectares.
Yes. Now, your Lordship, kindly come to the schedule of property. He is describing his own land as a government land by increasing the measurement from 1.20 to 2.40.
No, where is that schedule you showed us?
140.
140.
Yes, no, his is 2.4 hectares. That is page 108 you showed us.
108, 1.2, not 2.4.
Oh, I see.
That is, in fact, the change is brought out in the claim so that he can obtain some order in respect of 1/20 by increasing the measurement.
Area.
Now, your Lordship, one more thing. In the entire claim, your Lordship may kindly come to page number 138. Where is the challenge to the any order of 9 July? 138. Prayer may be seen. Your Lordship, there is a difference between writ application and suit. If you have not prayed for a particular thing, your Lordship, you cannot claim on the basis of.
Yes, he is claiming over the suit land.
Yes,
Title, declare my title over the suit land.
but he has not challenged 9th July order. That's what I am submitting. He has not challenged 9th July order in the suit. Even in
How
the.
can he do so? Because he can challenge under 202 order, he can challenge in connection with by raising a suit. 202 order can be challenged in a suit. There is no requirement for him to challenge any earlier order or a same day order passed in 1/20 under by the Tehsildar.
Even assuming for argument.
No, there is no requirement for that. That separate challenge has to be borne out because his case is I am 1/3 240 going by your stand. So you give me protection over 2.4 hectares,
Yes.
which you are arguing that 2.4 hectares is over and above his entitlement of 1/3. He's trying to increase the quantum of land so that he gets an indirect protection upon 120. This is your argument.
Yes, because yes, this is my argument. But my argument is also one, Your Lordship, that 120 is at no point of time was part of 1/3. 1/20, that's what initially I showed. The survey number was 1. which was divided into 1/20. It was not a part of 1/3. But by increasing the measurement, he's trying to bring that one also within his land. That was in his interest.
Yes, what do you want to say?
We have already complied the order. now.
How do we see that you have
On the
complied?
compliance report, you know,
So you have left his post.
1/3 is untouched.
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 Once I
Civil
see
suit is
one
pending.
to nobody has
such
touched.
a civil suit is pending,
Nobody touched.
and the honorable single bench has also
It is not. it's
observed
not-
that,
yes.
only 593 order, my lord, is not under, since it is not under challenge, that eviction order has to be executed. Order number 593.
593, that is the 202.
102.
No, that is page 88.
Not way, that
Uh,
318.
1/20, which has been.
It is 593, sorry,
Five.
592 is of 202.
Mine. That is the.
592 proceeding is pertaining to 202, page 125.
Yes.
Yes, Mr. Jayapal.
To reply or not. But Mrs. Nag have argued strenuously that I have not challenged this order, but I have not brought close judgment, which says if any administrative decision is taken and if it is not communicated, it can't be implemented also, Lordship. Let authorities show, Lord, that these orders were communicated to my clients.
So that you have to have agitated by filing a writ, Mr. Jayapal.
Playing once again.
No, no, your argument is that administrative decision is a nullity if it is passed in my absence and not communicated. But sir, you did, but, but you did not challenge it on that ground, Mr. Jayapal.
It's my opening sentence of argument.
Administrative decision without service is a nullity. Very good.
And even if it is not communicated, can't implement my own that. If it is not communicated, let the authority shows that these orders were communicated right from the order of the deputy commissioner. None of the things they moved in a clandestine manner.
This is what is case.
It comes about science is plain once. Again, not just it's matter of facts at the cost of this repetition, I would say. The kind is the plain. Body of the plane, I'll show that refers with regard to RC number or pass under regulation 202. Page 137 of the plane, the kind is not. It's a page 137 stay application, paragraph 12. Not plane must contain only facts. I have treated the facts. Schedule comprised of my recorded land along with the excess, which is in survey number 1 of the 20. The schedule comprised of my recorded land because the trustee under regulation 202 order clearly said 1/3. So I made schedule 1/3 as the property.
But you enhance the area.
Excess land is 120. Not most. By the time it is mentioned as a
Mentioning the same
But there is one case coming before my lord, before the single judge, the scheme of 15 July 2003, which says, if I am having a landed property in my name, if I am having excess land, I am entitled to regularization.
No, Your Lordship, that's that particular
That is
scheme
certainly coming.
is not in message.
Sir, I would say, I appreciate Martin. This way, this can't be done. I appreciate.
In the evidence in opposition, all these things are not there.
Amount to prejudging the issue in the suit, because the suit, one of the things involved excess land in 120 because the order of the Tahsildar.
Did you apply for regularization of that excess land?
No, it's not in a deal.
Never,
Inquiry has to be made in the ground realities.
never happened.
Yes.
Sir, you have passed this order that is 125, page 125. That is you have also mentioned 2.40
I
hectare.
have not
What-
watched Your Lordship.
The
The authority is Your Lordship.
Yes, authority.
Even I
In-
don't know.
in that case, you did not mention that government land extends to 1.20 hectare. Why 2.40?
No,
You are saying that you will not touch the area of 1.20 of Ritesh.
madam, he is in unauthorized occupation of the excess land, my lord,
Excess lands.
of government land. That is the
Excess
government
area.
excess area.
Excess area, what is the area?
It's
1.20.
1.20.
But that order mentions 2.40 hectare.
That is included within your order. Come to page 125.
Why not 1.20?
that protection can be given to him. So I'm saying that. You know, 1 minute. There is no
Let's not raise this issue. Please.
The second order of 9 July has been stayed.
Whatever happened.
Nobody can stop the implementation of that order. Your Lordship.
So you are not taking his 1.20 hectare.
No,
But it is the subject matter, page 125, Miss Na kindly come.
125.
125, the penultimate paragraph says that unauthorized construction needs to be removed forthwith pursuant to 3 years. Whereas during revenue survey, it is noticed government land of 1/3 of 2.4 hectares.
This is 6.74. Nobody is touching this. Nobody is touching this.
So we can record
Yes,
this.
page 125, Lord.
So that is has been recovered. That no.
No, that 2.4, which argument you made that he has enhanced the quantum of land in 1/3 to include.
That is the subject matter of the.
No, your argument was that it was made 2.4 so that he can include the land under 1/20. That was your argument.
So that he can include the land, excess government land, Your Lordship. 1/20.
Not 1/20, my lord.
One is that one survey number, 1/20. His intention is to occupy that land. My intention was that, not to include, occupy that land, 1/20. By mentioning that measurement. He is the owner of 1.20 only.
Yes, we can give him some 1.20 protection.
Yes, Your Lordship. We can only one.
1.20, 1.3.
1/3.
1/3 at 2.4 hectare to state. Page 125 has been stated. This was the subject matter. And this does not include that 1/20 hectare.
And learned single judge, Your Lordship, has observed that particular thing. The stay is in respect of different thing. This particular order of implementation is in respect of a different survey.
The present appeal has been preferred. Hello, when you will send me the non-paid pen drive, na first running these papers.
Means today, everybody they tell me 1/20, 1/20.
Don't do it, miss me. Alok, please include one line. Uh, in our discussion, we will just include one line that uh, the land under survey 1/20 also have not been incorporated.
Will be bought by the family too. The food was by two dogs. Possession and mental cruelty. Possession and mental cruelty. Possession was not allowed. Strict. And the mental cruelty law was allowed on the ground that in the PD, earlier PD, there was no mental cruelty alleged, but subsequently, if you have
Sorry, we didn't follow. What did you say?
to be plain,
Yes,
mental cruelty was pleaded, but not to that much. But subsequently,
by a amendment they brought into it.
now is that during the pendency of the suit, the wife made complaint against the respondent, alleging that the respondent is having extramarital affair with his colleague. So that amounts to mental cruelty, and judgment was delivered on that point only. But there are evidences.
The possession was not set aside, not touched. Yes.
Then subsequently, after the delivery of judgment, I got a order on the same point that when the respondent was serving at a remote island, a tribal island, he constructed a house and he was living with this lady, whom I complained of relationship, legal relationship. The public made a complaint and inquiry was conducted, and it was found that it is true, and the authority imposed penalty. So I want to plot this document by way of Order 41/27. Additional document I got subsequently. It has been proved. It has been proved.
So have you filed separate application 41?
I discovered 7th is coming in Chennai. So 7th is coming. Because I want to get my application on 41/27.
70s?
On 7th of this.
Yes, what is coming?
My client is Chennai right now. My client. That appellate. So I want to make an application at Order 27 to bring this document, the additional evidence. This is the core issue on which the petition was allowed by the family court.
But there are 5 reports against you, inquiry report, that the allegation of adultery or something like that has not been true. Is it correct?
Put by this department. Two more. It's not my complaint. Two more. Public made complaint. It's not my complaint. It has been proved. And penalty was imposed.
Give 2 copies. This order was of 31st January 2022.
Subsequently, government.
When was the decree? Decree was on 9 July 2023.
So
So you didn't bring it into.
Later I got it. Because department proceeding, I had no access to that. Not on my complaint. That's why I.
Whose complaint was it?
Public made. That tribal.
So this is still this has been continuing.
Penalty was imposed.
Penalty imposed. No, where do you find?
Departmental proceeding, the inquiry officer,
We should come back to you.
Therefore, taking into consideration all aspects of the case, the undersigned being the disciplinary authority will impose penalty of such.
under what is the charge?
First page, first page.
First page. Same ground, same point. The same lady.
You alleged relationship with two ladies. One was Shakuntala and the other was Sumitra.
Sakuntala. This leads to Sakuntala.
So you have to take all the evidence.
Other means of
So how the High Court can do this?
we also allow you to have this by way of-
Division does so. Terminally on
So there is a view. But if it is found that.
What do you say, Mr. Khan?
This proceeding by the appellate authority exonerated me. But on the ground that I am a disciplinary force, so some penalty was imposed. This penalty is
Appellate authority exonerated you, meaning?
inquiry officer. It did not found that there was a they were residing together.
Then why the punishment was imposed?
Because appellate authority, considering the fact that he is the disciplinary force, so he has constructed the house without
The
permission.
disciplinary authority passed this order.
Disciplinary, it's appellate authority.
How appellate authority?
That
This
is
is why commandant.
that is the challenge before the tribunal. That proceeding is pending.
Oh,
That proceeding is
challenging the charge sheet
Yeah, charge inquiry report
and the final order.
Yes, you know.
Then the final order was passed by the disciplinary authority.
No, appellate authority is also passed an order.
Where is that?
It's not a. I will provide that.
Then how can we hear them? So, have you challenged this order
Yes, yes, yes. Before the Central Administrative Tribunal, because I am a government servant, I have to challenge before the tribunal.
But you did not say that during course of hearing.
No, it was not brought into the notice of the court because
Your client doesn't know.
No, no.
Your client, against your client, a charge sheet has been issued in 22.
Yes.
He will not say that, my lord, there is a proceeding against me.
It was the duty of the other side to bring all these things. It was the other side ought to have done material against me because he is
So you suppressed. You suppressed.
It's not suppression. My suit is 2015.
We will set aside and send it back on remand. You try to let them try
Question
to.
of sending remand does not arise. Because last occasion they submitted, they want a settlement.
So you settle?
No.
They want a settlement.
Settle. We are not stopping you. You settle. What can be the settlement? Tell us. We will record.
You are registering divorce proceedings.
Last 15, 16 months, they are separately.
My client has a demand that she wants a flat. He fulfilled
That
that.
is a different issue.
That different.
The mediation has already failed.
Very good.
Mediation fail.
Mediation has already failed now.
If you want to bring this document on record before this court, I will get an opportunity to file objection and close all the
Right.
documents.
You will certainly get an order.
Yes.
But the thing is, which we were desirous of finally disposing of the matter. This was not told
This
to
was
us.
not brought into the.
You also did not tell it us yesterday.
It was not amended, written statement was not amended by them, by incorporating these things. It is settled the unfounded allegations raised against the husband or against the spouse. If it is unfounded allegation, it is amount to cruelty. Several judgments of this court also.
We have gone through but this was a new document has been produced.
But he ought to have amended his written statement at the time when he got this document to bring some material, because in the pleadings, they allege only the Sumitra. Now they are alleging another lady. So every day they are changing the extent.
Shakuntala.
Statement.
Now, Shakuntala also be mentioned
In the written statement.
in the complaints which were lodged.
The complaint that is mentioned, but in the written statement. there is no
Mr. Khan, now the situation is such
Yes.
that you have not been, this allegation has not been shunned as yet. It is under challenge by
Yes,
you.
your lord.
So the thing is that if this is placed, court has to take it into consideration, granting you appropriate opportunity to deal with this.
Yes, your lord. Let him file 4127 petition. And closing this, I will file objection.
Dispute for you.
Because he is submitting half Take care, not the complete.
When can you file the section?
Friday.
7th is coming by 8th and 5th. From the affidavit. He's coming to the station. 7th is.
Now, how long will you take to give a reply?
1 day.
It will take 1 week at least. Because document I have to enclose and all this.
This is a departmental inquiry which has been conducted. All right, it will be there on 7th.
It is matter of a record. I cannot deny this, but this ought to have been brought before the trial court by the respondent.
Very difficult. This is your document. This is very difficult to get.
No, he get the documents.
এটা কি 8 তারিখ রেখে দেবে তাহলে 8th.
Okay.
We are not passing any order today. 8th, you file the application in the department with copy to him, we will. Chalo.
respondents were directed to file their affidavit in opposition.
Who
4 weeks.
is your other side? Who is your other side? Have you given a notice? Are you there, Mr. Divedi? So why you are not filing your affidavit?
I'll check it out.
Monday. Yes, next.
But there is one more WPA, Your Lordship.
WPA, same thing, or it's a new matter?
No, Your Lordship, this is a long pending matter, Your Lordship, with regard to promotion.
Affidavit is not exchanged. Then what is the use of bringing it in the list?
Affidavit is completed, Your Lordship.
Which one completed? Which matter? This was is completed, the later the other. And that one, no affidavit has been
No,
filed.
Your Lordship.
Other Mr. Divedi, check up if you have, if they, then you file the opposition by Monday, then we can keep it in the list.
I'll look at it.
এইটা তাহলে দিয়ে দাও, ওটা রাখো। Monday দেবো। Yes, call the list, এইটা বন্ধ করে দাও। Switch it.
Item number 1, WPA 179/2025. Your Lordship, I am appearing for the petitioner, Your Lordship. The petitioner herein is a company.
Service is complete. All right. Yes.
Your Lordship, the petitioner herein is a company.
Hmm.
What happened is, Your Lordship, when e-auction was held by the State Bank of India, after which the petitioner participated in the said auction and he was declared as a successful bidder in the said e-auction, and therefore a sales certificate was issued in favor of the petitioner.
Hmm.
On the basis of that sales certificate, the petitioner approached the respondent authority, which is the Tehsildar, in order to get the mutation done with respect to the land.
Hmm.
After submitting the application for mutation, a Form J was issued by the respondent authority. This was issued in 2018 and it has been 7 years. Till now, there has been no update with regard to that mutation.
Now, what were you doing? What were you doing?
The petitioner had approached to the respondent authority several times, but there is no response from the side of the respondent authority. Even the application was submitted.
Where is your last representation made? You have annexed nothing.
Your Lordship, Annexure P7 may be looked into, Your Lordship. After my application being submitted, the respondent authority themselves has issued Form J, Your Lordship, which is notice of mutation.
Hmm. But this was issued in the year 2018. We are in 25. Only 7 days ago. What have you been doing for so many years? You are also not interested.
The office of the respondent authority several times.
When was your sale deed?
Assurance. He was getting an assurance that the mutation would be done.
Assurance has been broken, so you ought to have approached them. No, yes, madam, what is your instruction? Dispose it off. Yes.
Whether any agrees or not, I think, what I find from Form J in law,
Yes.
chief manager SBI. and
Hmm.
some District parties were given notices and why it has been delayed.
You conclude it, na? Whatever you notice, authorized director requested for mutation.
And the mortgage on.
Annexure P6 is the sales certificate, Your Lordship. That will be noticed.
No, who is this, this Enterprises Private Limited, your sale had been challenged in any proceeding?
The third person to whom the notice has been issued, that is
Yes.
Construction, that person had mortgaged the land with the State Bank of India. And as he could not repay the loan amount, the said land was auctioned. And during the auction, the petitioner participated. And after participating, he was declared as a successful bidder, and therefore sales certificate was issued in favor of the petitioner from the state bank.
The grievance of the petitioner is, the grievance of the petitioner is
Number two. Here, 180 of 25.
yes.
Here, this is, here the division bench passed the order and held that the petitioner's land is a license.
Hmm.
Division bench order is there, and it has said that the petitioner's land is a license. Thereafter, my lord, the estate officer
Hmm.
assumed it's a grant land, passed an order under the Public Premises Act.
Hmm.
Assuming that it's a grant land and passed an order under the Public Premises Act.
Hmm.
The petitioner himself, thereafter, he has challenged that order before the state appeal. Thereafter, he has filed the civil division also lost.
Against the order of the unauthorized, appeal preferred lost, then revision lost, then what hope is there?
Saying that he is a grant land. He himself was saying that. But in the divisions by the order, but can you see one?
Division bench order came from the dismissal of which writ petition?
That is the writ petition, my lord. I'll come to that, my lord.
Have you given copy to her?
My lord. There's an urgency because as per that, my lord, on 26th, the order has been passed, eviction order, under section 5(1). And so on 29th, they have diminished some portion of the land, my structure. My lord, I'll come to that.
Later complete, yes.
Page 28, my lord, annexure P3 is the division bench order, my lord. The operating portion which I'm referring, my lord, it's page, my lord, page 35 first, my lord. Page 35. Page 35.
35.
Page 35, my lord.
Yes.
Says, my lord, the aforesaid facts narrated here and above are more or less undisputed, and the writ petition filed by the respondent was founded on 2 points. This, my lord, this appeal was preferred by the administration, and I was the respondent, my lord. So, the writ petition filed by the respondent was founded on 2 points. Firstly, the land was settled as a grant in terms of the regulation 4(1)A of the regulation of 1926 for a period of 30 years, which contains the provision for renewal thereof, and therefore, the action of the authorities is not granting renewal without any justifiable cause in per se illegal. Secondly, the initiation of the proceeding of the deputy commissioner under regulation 1966 is without restriction, as a proceeding can only be initiated under PPM. This one. Then after the single bench, while disposing of the writ petition, held that first point in favor of the appellant authorities, holding that it was not a grant but a license under regulation 1B of the regulation of 1926. My lord, the land was given in under the regulation 1926. Now 1966 is there. 1926, regulation prepared manner. Thereafter, the 1966 regulation came. I was given with the license in the year 1959 for 30 years. It completes on in the year 1989 only. Prior to that, this new act has come.
Very good.
Now, it has been.
Now, you please complete that paragraph. So the writ court said that no automatic renewal does not postulate any automatic renewal. Was not a, but a license. And on the second point, it was held.
It has to be initiated by the estate officer, not by the deputy commissioner.
But it was a proceeding under PP Act. The deputy commissioner,
So, the baby
what did you challenge in?
eviction that have challenged. He has no right to pass an order.
So very good. Then what did the writ court say?
So, it's wrong, cannot be.
Done by the deputy, it has to be done by the estate officer. Hmm.
And then he wants the 41, page 41. Madam.
Page 41.
Page 41. The same order is clarified, madam.
Yes.
Inevitably, the license was granted under regulation 41B of the regulation 1926 for a period of 30 years, subject to the general conditions and strict therein. The initial proceedings initiated between the parties would evince that since license was treated as a grant, because we were in the impression that it is a grant. So proceeding was initiated under the grant license, not a license, grant land. Grant land is for 30 years, madam, and license is, this is under section 413. I will show that land tenure.
Sir, please let us understand.
Grant under regulation 41A of the regulation 1926, but such contention was not accepted, and therefore the respondent cannot contend in the instant proceeding that it was a grant, not a license. The stand of the respondent at the later stage of the proceeding would also corroborate the said fact when the respondent abandoned such claim and accepted the position that it was a license granted under regulation 41B of the regulation 1926, not a grant under thereof. But undisputedly, the period of license granted on 18 September 1959 was 30 years, which expires in the midnight of 17 September 1989. The prior permission was granted by the authority to transfer and convey the residual period of license in favor of Captain Datta and original licensee by exiting the sale date 1960 transfer the convey. This was done, Miller. Now the last order is Miller. It's at page 41. So everywhere the court
41.
it's a license. 41, 48 Miller last. Accordingly, the portion of the order by which the restriction of possession was directed is hereby set aside. The appellate authorities are restrained for dealing with the property in favor of any third party for a period of 4 months from date. If the appellate authority does not initiate a proceeding under the Public Premises Act within the time indicated here and above, the order of single bench directing restoration would be. My lord, here direction is given, but direction is given to initiate a public hearing. But before going and before passing the order under the Public Premises Act, it has to be declared as unauthorized occupation. Because license is there, madam, it has to be terminated first.
Her license was there for 30 years. 89 expired.
Can you say something?
So how can I sitting singly can interpret the division bench order? On the basis of the division bench order, the proceeding has been initiated.
What has said, held that.
What is Supreme Court, sir?
This can be first license has to be terminated, then as per the new regulation. 162 is the extinguishment of tenancy.
That you ought to have argued before the appeal court. That don't do this. This will create problem for me. If you accept, then the estate officer has the jurisdiction.
Without extinguishing the tenancy, he has passed the order. First, he has to extinguish the tenancy as per the New Act.
How can the estate officer extinguish your tenancy? It is proceeding on the basis that there had been extinction of tenancy. Part has over, proceeding has started. Show us the single judge order, show us the single judge order. Where is the single judge order? That is page 64.
No, my lord. It is not that order, my lord.
Is not that order?
Not annexed, my lord. Single judge order
Yes,
is
sir.
not annexed. Because after I'm accepting the division bench order. I'm not denying. I'm accepting everything, my lord.
No, no, what did the single judge say? Single judge said it is a license. Single judge said it is a license. Very good. And what was the direction? That only it cannot, as it is a license, you are not the competent authority to take the decision. So I am sending it to the estate officer, something such
Yes. Okay, division bench.
division means a single means. There is no provision for automatic extension of your period. Then when the renewal goes, you had lost your right in the year 1989. Hmm.
Yes,
Hmm.
the new act has come into.
Next new act has come that you ought to have argued before the appeal court. আরে, আমি বোঝাতে পারছি না। I am sitting in a single bench, madam. Yes,
One minute, 141. 141 of the act, my lord. Regulation. 1966, my lord. Regulation 1966, my lord. Kindly come, my lord. 141. It's classes of tenants, it's mentioned, my lord. And the division bench has said it's a license. License comes under 145A, my lord. Before that, it's said, my lord. Come to the prayer portion. My lord, kindly, my lord, kindly, my lord. Application is not.
just a moment. The order দিয়েছে Yes, what you are saying?
850, madam. The order, first order, proposed notice was given by the estate officer. Wherein it is held, madam, which para 4, para 3 and para 4 manually same, madam. And whereas I am of.
No, your the license, it was a license. The license will stand valid for 30 years. So 30 years takes you to 89. In the midst thereof, the new regulations came. New regulation is of 66. 66 regulation provides what? That it will be automatically extended. So that automatic extension argument was advanced by you.
No,
Yes, now the court says that kindly we cannot, you kindly come to page 47. No doubt the provision under 60 provides that land would vest in the central government. This is another. That point must have been dealt with.
with regard to this 1%, it is not done.
Show us now that you have argued that. Show us that from the order.
Because these are.
Show us from the order. But madam, you are not understanding one thing. Unnecessarily you are wasting time. We are asking you, you show us that portion of the order. That you argued this fact that when the new regulations have come, automatic extinction is not there. Even if it is, you have to terminate my license. That is your argument. Isn't that your argument? That under the new regulation in 66, there has to be a termination of the license.
It's a grant land, not a license land. Now it has come, it is a license land. So license land means, madam, it has to be terminated. It's not a grant land for a particular period. It's a license land explained in the 1966 Act, madam. So we have to go with the 1966.
You bring the single judge's order. What is the single judge's order?
Whatever I got,
To file a supplementary affidavit today.
but the eviction proceeding already started, madam.
That is done in terms of the, you do not prepare your matter, madam, what we can do. This order of division bench was passed way back in
Madam, there are
20th September 21. Proceeding, now in proceeding, where you,
grant land. Whether, but the division bench has said it's a license land. He is stating that it's a grant land, so you have to, but it's not a grant land because the division bench has already held that it's a license land. So for license land, it's another procedure has to be followed, madam. It has to be extended first. Then
So-
the another-
so this estate officer order was challenged by you before the appellate authority. You must have taken the point there. Show us the appellate authority order.
There also the grant, because in the same grant.
Then how can we help you? Show us the revision court order. Nothing you have annexed. So show us that without that, how can we decide?
Order is that.
একে বোঝাতে পারবো না। Will you bring the orders, madam? Will you bring the orders, madam, or not? Tell us.
Single bench.
Where are those? You're fighting the battle without any sword. I thought, you are a counsel engaged, you should thrash your client that where have this been argued? Show us the document. We are not annoyed with you. We are annoyed with the case, the matter in which it has been dealt with. You have to show us, give us some handle so that we can give you protection. You know, document, nothing. Everywhere, to show that to us that everywhere I have agitated the point, it was not considered anything. Then I can help you.
If it is as a license.
Then you are not understanding anyways. Tomorrow,
Well, I will file the supplementary, madam.
when will you find?
Tomorrow, I'll file.
When is the, now it has been, there is a structure there. Is there
There is a plantation.
plantation?
The walls,
This order of the estate officer, when was the division dismissed? When was the revision application dismissed? Where is the appellate authority order? 13?
13th of March 2025, madam.
Page?
Page 64, madam.
See, there also you did not take that point. And it was a frivolous application, the court has observed.
The state, this district judge also, the state appeal is also cases. It's a.
The state appeal that against the state appeal only this civil division has been filed, but thereafter this order has been passed, 67.
Section 9 is very clear, my lord. Against the order passed by the state officer, he has to file before the district court.
He has filed it, madam.
That has been done. Appellate, huh?
Yes, order. 7
This was the order of the,
to the order passed in
Madam, it's passed, and we can this order, first order, madam.
where is the district judges, where is the district judge's order? You have never argued this point. You have never argued against first order was first. Hmm. Hmm.
Section 4 of the Public Premises Act, show cause was issued. Wherein it was held that it is a grant land.
Where is that?
Para 3, madam, sorry. Para 3, it was held that, para 3, area so and so, Calcutta village was granted lease of KC Kuruvilla.
Hmm.
1959. But wherein this was initiated on the basis of the division bench order, madam. But the division bench has held that it's a license. Then why the estate officer has stated that it's a grant land? That is my first point, madam. After the division bench order only, this has been started, madam. This eviction proceeding has been started, madam. When the division.
Just a moment, just a moment. You went up to the appellate authority challenging which order? So, show cause notice was challenged before the appellate authority. Where have they built any discussion you find as regards the grant or as regards the license in the district judge's order?
Same thing for a grant.
Show us that.
The district judge has also this same thing has said, madam, 61 page 61. I further find from the order.
Just a moment. Focus was of 2015.
Then 2021. After the division bench order. Division bench has passed the order on 23rd
Come to page 55. Second paragraph you place. It is your case that it was for a period of 30 years as per 46 of the land reform regulations. It will be for 30 years with an option for renewal. Submitted that since the said license was given 59, then its validity till 2019. This is wrong. 69, 70, 80, it will be 2089. But before expiry, proceedings for eviction was started in 15 by the estate officer.
Deputy Commissioner, by the Deputy Commissioner, that order was challenged. Because in the division bench order it says held, my lord, the DC is not the authority. Because the public.
Don't repeat, we know that. Yes, madam, what is your stand? It doesn't appear that it was treated prior of the. Yes. Hmm.
The order is 22/12/2021.
Where is this order? 21 order.
For 2021, now they're asking.
No, that is the show cause.
There is not. In the state of the proceeding.
Where do that did you find anywhere that line was there? That can only be understood from the single bench order. Come tomorrow with a supplementary affidavit annexing the copy. Can you file tomorrow? That will be prejudicial to you. Acha, Miss Learned Advocate appearing for the Yes. Yes.
I have participated in parliamentary elections 2019 for providing videography and photography. And each tender was invited by the office of the deputy commissioner. And the copy of the e-tender is at page 24. Please, what is it? Sorry. Page 24, e-tender. Got it, Pranav?
Yes.
My e-tender was, I participated in the e-tender was accepted. And page 28. The subject matter of the order is providing of videography and photography for the coverage of the election related works for conducting parliamentary elections. 2019 regard. I have provided the videography team. Last photo at the end, they have mentioned you are requested to direct the videographers to report to their respective teams for on or before 12th March 2019 without fear. Then at serial number 10, the in charge video surveillance team with the request to engage the videographer as and when required. Verified names.
In charge of the video surveillance team.
They have been appointed various teams for the purpose.
You are also video surveillance team.
No, I am not there. I am only a videographer.
You are only a videographer.
Videographer. I have appointed them a videographer, and they have to take the services of the videographer as and when required.
So your job is to provide the videographer.
Only videographer and photography as and when I am done.
So by this letter, you are directed to direct the videographer to report to those places. You are videographer.
Yes.
Very good. Then what happened? In charge, why did you show us clause 10?
Which one clause 10?
Engage the videographer as well.
Is the videographer.
So you are the who is the in charge of video surveillance team?
They have appointed different officers for that.
They are government officers.
Yes.
With the request as per the requirement. Very good. So this in charge video surveillance team is a government officer.
Yes.
Very good. Then
He's a team leader.
Team leader.
Asked me yesterday.
Yes, yes.
Who is the team leader? From various departments, this persons are selected. He is a kind of a nodal officer who will.
I see.
Start coding.
I see. Nodal officer.
Only under their directions the videography is to be carried.
Then
And
what
if
do?
Your lordship come to the page 31. Here is the example. What is the role of this team?
31.
31.
Yes, what is that?
This is the way the team leader has to sign for how many hours the videography has been done at what point of time. Duration of engagement of the videography. That is mentioned, it has to be countersigned by the team leader.
It has to be countersigned by the
Team leader.
where you are reading.
Page 31. It is countersigned at the last column, team leader to be.
This team leader is at page 28, which you showed.
Team leader is, yes, sir.
The in charge video surveillance team.
Yes.
He is the nodal officer, is the team leader.
No, they are saying not only, sir.
He is like a nodal officer.
Very good. It is the in charge. Very good. Then this was done on 2nd. Yes. Then what happened?
Thereafter, the bill was submitted.
Bill submitted.
Bill was submitted.
Where?
The copy of the bills are next year. It starts from from 31 onwards. All the bills are there.
This is daily statement of videography on parliament election.
Thereafter the bill,
Where is the bill?
BD, just a minute. Page 55.
Huh?
Page 55, the bill is there,
55.
55. Page 24.
Page 55.
55.
These bills were submitted in 2019.
29. The
Huh?
last is at page 124.
Which are the pages? Page 31, you said.
Page 55, my lord.
30 is also a bill.
30 is bill.
How 29 is also a bill.
Then page 52,
29.
55.
So these bills you submitted to whom? To the deputy commissioner. Very good. Then what happened?
Thereafter, they have released 5 lakhs.
They have released 5 lakhs.
And this we will get it from para 8. So by application, page 30.
Oh, they page 30.
Page 13 of my application, paragraph 8 of my application. That after locking the door of all the concerned, after a lapse of about 2 years, District Commissioner South Andaman released a sum of 50 lakhs, white check number such and such, on such and such date. I have enclosed a bank statement in support of that this money has been paid to you. Now the remaining amount was pending with them.
What was the remaining amount?
Remaining amount was,
Where is your representation after you got the money? Where is your statement? P6, where is the statement? P6. Page 144.
yes, 140. What is the statement of the bank? Where the 5 lakhs rupees have been deposited in my account.
Yes, in 22. Yes, then what happened?
Made several representations about the remaining amount. When the
What is the remaining amount?
remaining amount is about what 76 lakhs, as it appears from my.
Both matters are the owners or proprietor of the both item number 3 and 4 are the same, so he's combining both the.
No, I'm not combining. That is also the.
Court matters means?
For next item.
Oh, court. Oh, you are combining those two.
No, I'm not combining. Please, that is a.
What is your total claim? Come to your advocate notice, page 140. How much did you demand from them? That what was the remaining amount? You were called for a hearing, page 145. Page 145, please come.
145, when my recommendations are not replied to, I find the written application is live. And once they have received the notice, they have received a notice that there is going to be a meeting to discuss about the outstanding things. Kindly have a look at the page 45.
Where is that writ petition? You have already filed. What was the order passed in that?
Dispose of the recommendations in a period of 8 weeks.
So that is page 146 order of.
Page 146.
Oh, I see. So you went to the writ court as per writ court direction?
Right.
Now,
To dispose of the recommendations in a period of 8 weeks.
very good. Then what happened?
They have not done anything. They kept going.
Then,
Only at page 49 it will appear that on 21st of May 2024,
yes,
issued a notice that you submit the information of these 4 points.
the deputy commissioner.
Yeah.
Very good.
Then
Then,
these points, petitioner asked to submit a written submission on the following point,
then,
execution order, all these.
then the final order is page 159.
final order is no one. Thereafterwards, I have submitted my reply on 28th of May 2024. 28th May 2024, I have submitted reply. My reply is covered by application at page 150.
Page
One
one.
reply has been submitted. Page 150. One by zero.
No, where is the documents were called from? Where is that page? 140. 149.
149. 149 is the order which is passed on 21st of May 2024. Asking for additional submission on behalf of the petitioner from the 5 points. But when
Yes.
the reply was submitted from the advocate and the reply starts with page 150. Next page.
Now come to the final order. You are challenging that.
Once I have submitted the reply on 28th of May 2024, thereafter nothing was happening. The applicant was, petition was having no other activity but to file a contempt petition. Contempt petition was filed on 17th of September 2024.
Hmm.
I have an extra copy here.
Hmm.
At page 154.
Hmm.
The moment I find the contempt petition, they pass the interim order, which is at page 155.
Interim order?
Real part.
What an interim order.
Interim order, yes. Come to me.
Yes, please, the order.
Page 155, there is an order which has been passed on 24th of September 2024.
Hmm.
And the operative part I just read now. At page 156, whereas examine the case of the petitioner, it is observed that from the copies of the videography and parliamentary election 2019 has been submitted by the team leader are available with the file. But there is no document to record which indicates the original DVDs were submitted along with a copy to the election of. Further, there is no record evidence to show that the records were submitted in the prescribed manner for time. The representation dated such and such of the petitions are hereby disposed of in the direction to submit the acknowledged receipt. Acknowledged receipt.
Hmm.
Further submission of DVD videograph in original with all documents records as mentioned in terms and conditions laid down in the e-tender. The purchase officer is directed to put up the file after the receipt of acknowledgement for submission of DVD and photographs. The plain copy of this interim order.
Hmm.
This is the interim order. The plain copy of this interim order be served upon the writ petitioner, the chief electoral officers.
Now, who is this purchase officer?
That is of the subordinate of the rectification officer.
That we know, but did you make them, did you make that in charge? He is a government officer.
He was not there. He was only concerned with the handling of the deals.
Very good. Now, what is your argument? What you are saying? Why this order is bad?
Why this order? Why? This order was passed. District officer and government leader.
Deputy commissioner.
Plain copy of this interim order is served upon the writ petitioners, the chief electoral officer, Pandaman Nimbar Islands, the deputy chief electoral officer, and Islands, case officer, district officer, and the government leader. Why it was from the government leader?
Because content was pending.
Content was pending. This was passed. Thereafter, 2 reminders were sent. That is at page 167. The first reminder which was sent from the side of the leaders, the deputy minister. 157.
What is the date of this order at page 155? This interim order?
This order has been passed on 24th of September 2024.
Very good. Now the contempt application was disposed of thereafter.
Final order,
Yes, next.
final order is at 1. What will they say in the final order? This was passed on 21st of.
Kindly first come to page 158,
150. And also
157 and 158.
157 and 158 is only a reminder to the earlier order which was passed on 24th of September 2024 by the decree.
Hmm.
24th of September 2024. The order which was passed by the deputy minister,
Hmm.
continuation of that,
You were asked to give the acknowledgement.
I was acknowledged and receipt of the videogram. This was again asked. Now these were not solved the problem.
What was not, sir?
This order that came from 57,
Hmm.
reminder,
These were not served upon you.
they were basic. They don't be a copy.
Very good. Now,
Thereafter, they passed the final order, which is at page 1. At 159, they say, where is the operative part? From the second paragraph, I read it out, and whereas this court observed, the petitioner has not complied with the clause M and N of the conditions specified in the e-tender notice dated 31st of January 2019. The clause M and N are at least the clauses. Full videography of each event should be done. The original copy of the short DVD photograph with negative should be submitted to the resident officer authorized by the district commissioner on the day within 3 hours on completion of the coverage of the event. What is required to be done within 3 hours? Along with the additional recorded events. The original copy of the coverage will be the asset of the department. It should be submitted in the original without any alteration. Copy of this should be provided to should not be provided to anyone without department information. So it has to be provided within 3 hours. Now after 5 years, they are saying that you submit it. They are taking the different step. Why this different step has been taken? By respective promotion because I have filed the contempt petition. Only to get rid of the contempt that they are asking for. What they say further. Any is not required, and whereas ample opportunities have been given to the petitioner to represent this case. Ample opportunities have been given to the petitioner.
Very good, sir. Why didn't you take the acknowledgement? Finished. The game would have been over.
I have submitted, that's why they have paid the 5 lakhs. If I have not submitted.
That is for the 5 lakhs which has been submitted. You must have shown them the acknowledgement.
Because the moment the videography is over, the recorded events it has to be given to the concerned officer.
Which document shows that you have given that? Which document shows that you have given that videography content to the concerned officer?
If the videography was not made, then what is the purpose of holding the videography?
Don't go into those aspects. We are on a contract in between the government and you. Contractual obligation, writ petition automatically does not lie. There are thousands of judgments to that effect. You have to show us what was the arbitrariness on their part.
On their part.
For that, you have to show us that as to whether there was any requirement to avail acknowledgement after giving the copy to them. You have to argue in this fashion.
I'm asking a question.
Yes.
I have submitted my. They have accepted the request. They have made entries.
They have paid the amount. 5 lakhs done.
5 lakhs they have paid.
If only we are not 5 lakhs done. Then you said that I have had that dues. Then the officer has said that.
Out of that total amount they have paid.
Hmm.
Out of the total amount of 81 lakhs, they have paid me 5 lakhs. 5 lakhs they have paid to me.
Hmm.
Thereafter, as I have shown you at the page 145, they
Yes.
had a meeting to discuss what? To discuss about the releasing of outstanding bills. All the bills are outstanding. Only a proportion of these bills have been paid to me.
Hmm. That has now been rejected on the ground of clause M.
They have rejected. Now, in that case, that 5 lakhs are also should have rejected. 5 lakhs they have paid to me.
Be happy with that. Go and file a civil suit now.
So,
Go and file a civil suit.
you agree.
Your argument is that they have given only given 5 lakhs. So you be happy with that.
Fine.
Show us where is the contractual violation.
Contractual violation. Kindly come to the page. Clause M.
Clause M you have just now placed before me.
Clause M clearly says. I just read it out.
That you just now read page 160.
160. Now, within 3 hours on completion of the coverage of the event, and along with the additional recorded DVD. Within 3 hours. Further it says.
It's difficult to make you understand.
Fine.
I think I am not being able to convey to you what I am asking for. There is no use repeating that. You have shown it to me, Mr. Singh.
They are supposed to have, this is the property of the department. I am only.
Wait. Yes, Mr. Dwivedi, what do you say?
Finally see the tender at page number 24, madam.
Yes.
Here the tender is only in the estimate cost of the contract is approximately rupees 10 lakhs only.
Hmm.
Now, this tender is only for rupees 10 lakhs.
How can he claim 81 lakhs?
How can he claim 81 lakhs cost?
No, that
Should
only.
we do this evidence, which can only be taken in the civil court files of civil suit only. I am.
But you have not rejected it on that
I'm
ground.
not rejected it on that grounds. Also, that I should not say it, but my issue to reject it on that ground also. But aim and end is also not mandatory as is the terms and condition of the tender.
Where is that? Show us, Mr. Dwivedi, that acknowledgement is mandatory.
But page 25, these are the terms and conditions.
Show us which term, sir.
But this aim.
Yes, M does not say about any obtaining acknowledgement receipt.
The full videograph of each event should be done. The original copy of the record DVD photograph with negative should be submitted to the designated officer or official authorized by the Deputy Commissioner South Sudan within 3 hours on completion of the coverage of the event and along with additional recorded DVD. The original copy of the coverage will be the asset of the department. Now we have called our officer, we asked, inquired from our officers whether we have received it or not. They have said, no, we have not received.
Then how did you pay 5 lakhs?
Asking.
This clause does not make it mandatory that he has to produce the acknowledgement. Does it make it mandatory, sir?
On reading of it, it does not make it mandatory. But in order, since he's claiming a huge amount, that is also beyond the sanction limit of the tender.
Moreover, no, that we understand.
Something that you have submitted or why he is not.
That is no. Pardon?
But why he is not, if he have attended the deputy commissioner's vote on that particular day, he might have answered this question.
He did not attend?
No, kindly see what ample opportunity has been made 150. And whereas ample opportunity has been given to the petitioner, represent his case, which the petitioner has failed. Even after service of the reminders at his official address, the petitioner has not come forward. Therefore, in the absence of which, at his case, the undersigned cannot come to conclusion in the matter. We say we cannot come to the conclusion in the matter. Hence, the prayer of the petitioner for settlement of bills as mentioned in the petition and his representation cannot be allowed because he did not provide substantial evidence. And Malad, he himself, Malad, has produced that he has been served with the notices at page number 157 and 158. These reminders have gone to him. I must say, Malad, he will be in a better footing today if he has participated in this hearing.
No, this hearing was taken up on 21st October
21st October.
pursuant to an order of 13th October.
That is one of the contents order.
Yes. Why he will not appear? Did you give him any notice that I'm,
Page number 157 and 158.
where is the date of hearing fixed?
So these are Malad acknowledgements which are given.
You have to give 7 days requisite documents for taking further action in the matter. Next was on 14th October. That is after the order of contempt, after the writ petition, 14th October 2024.
20.
When was the contempt application disposed of?
That was disposed of last page.
12th November.
It was disposed of on.
12th November. So you gave a notice on 14th October that give it within 7 days. Request submit and 7 days.
Time for it. So he has disposed of this matter.
Entire
But he can,
exercise.
he is not providing a document, he is moving to contempt for that. This is not happening, this is not happening.
Let us use the single document name where they are sent. Nowhere, even the order they.
Mr. Singh, we have heard you. It's now his turn.
But
Mr. Dwivedi, how can you insist upon the person to bring an acknowledgement receipt
No, Bharat, because
which is not provided under the terms of the contract?
no, because Bharat, he definitely needs to have submitted some DVD, he has received some things.
So you ascertain the definitely, you call the nodal officer.
Officers maybe transferred to some other place, maybe retired.
That is your responsibility, sir. Or from the contract, you show us that there is a specific condition that after deposit within 3 hours, you have to get an acknowledgement. Anywhere, show it to us. Because that is also does not feature in your initial requisition. That is at page 149. Your initial requisition was work allocation order, number of days video coverage, number of teams, actual hours of videography, any official order issued for extra video coverage. These were the 5 requisitions. Now you change your stand. You pass an interim order saying that these are required.
But Bharat, he could not even be able to produce it.
That interim
He
order,
not even participated in the hearing. And not.
he could not have because
Tender time is only of 10 lakhs. I am taking this.
very good. Give him some more amount. Don't relegate him to a suit. Give some more amount.
By somewhere at least that he can call in evidence, he can call in document.
What I have to prove, Mr. Dwivedi, I have done the videography. I have handed it over to your concerned officer. Now you say that is a thing of 19. You give acknowledgement, produce the acknowledgement.
We have also sent his bills to the finance department. Financing department particularly asking this question when the sanction is of 10 lakhs, why he have.
Don't give him on that ground, reject him on that ground that 5 lakhs I have given, maximum you can claim is 10 lakhs. We cannot go beyond that. That is your honor to pass an order to that effect.
But this is my submission. I cannot go beyond. But what is in the contract?
Now, Mr. Dwivedi, you are our officer because contractual matter, RIT code does not intervene.
I understand.
So, but when in the conspectus of facts, it appears that something which you are calling for is not there under the contract. And it is right, you have said that the maximum value can be 10 lakhs or in between that. How can you claim 81 lakhs?
Because there should be sanctions, most sanctions, or if this sanction of 10.
So, where is 81 lakhs?
I have submitted the bill. All
Are
the
you sir, show us?
Can we have a look at my payer? The balance of amount is
Are the balance amount
71 lakh.
prayer will not. What is your answer to that? Tender was of 10 lakhs, they will give you.
But videography has been carried out under the instructions of the officer appointed by the deputy commissioner, who have been advised to hold, carry out the videography as and when required.
That is not been pleaded, man.
Why not? It is a part of your, part of my application.
Acha, where from?
Page 28. Paragraph 10, serial number 10.
Acha, why they are taking clause 9 that only Sony DVD camera or similar camera is valid?
Those might be the different conditions, guidelines and all.
So that clause also does not apply here, na?
But they have to give receipt that he is the owner of that camera and all.
That,
Because only Sony camera, Sony HDD camera, similar camera is valid for the purchase of the picture of the purchase receipt of camera and
Yeah.
the camera should be in the name of the owner of the firm. Transfer facility should be there in the DVC Pro HDD.
No, that is there. This also does not, Sony DVD, you must be having Sony DVD camera.
If I was not having, they would have not permitted me.
But personally, I have told one point number eight.
Even now.
You won't be allowed to have a participant to take video and all. I think.
My,
Personally, I'm not.
yeah, take all the one. Even now,
He's a good person, he's helping you. He's helping you. Otherwise, he would have been cantankerous. You cannot go into that, etc., etc. Ashok, the present writ petition. difficult to correct the order. Amount. শোনো না মনোজ, ওই যে সেকেন্ড পিটিশনটার প্রেয়ারটাই দেখে নেবে, প্রেয়ার এতে টোটাল অ্যামাউন্টটা দেওয়া আছে, ওই অ্যামাউন্ট hey, you should be thankful to him. He had been very fair. He had been very fair.
Grateful to you.
Yes.
I got to know some new things.
No.
The word which you have used.
No. Yes, next man.
Can go.
Next
They are
man.
enlightening for me.
Next. Then do I recall the order? Yes, next.
It is the-
Yes.
the order now. It is for the youngest.
বলো পরেরটা ডাকো।
Number 5.
Petitioner, my lord, the matters pertaining to the electricity connection on the last petition and direction was given.
Yes, what happened, Mr. Mishra?
Lordship, actually, we have calculated the estimated amount, everything was done from our side. But we have received a legal notice from a person stating that the land in which the writ petitioner is seeking electricity in the building, that is builded by the one Mr. I have the copy of the legal notice. Lordship. May I place, Lordship?
That should not bother you, Mr. Mishra, because
Because
you are acting under this order. Abhimanyu Majumdar.
Abhimanyu Majumdar, but our officer has written a letter to the Tahsildar to certify that whether the land bearing survey number 170 of the P, it is a government revenue land or not. But that report is still awaiting, Lordship. That is the difficulty, otherwise.
No, government revenue land, why that is required?
Lordship, because encroacher who has encroached the government revenue land, they are entitled to get the electricity connection.
Now
He is the encroacher as per him,
Yeah.
but one of the person has
made an allegation that he is not an encroacher.
No, not encroacher. He is residing upon the house which was constructed by the father of the objector.
Very good. You clarify it. It will be that the grant of electricity connection will not
We have written a letter to the Tahsildar to ascertain that, but we have not received that report.
not required.
Page number
Not required, Mr. Mishra.
And he has to fulfill that because.
Said the Tehsildar is not above High
No,
Court.
I am not.
High Court has said you have to do your duty. I am keeping it on Monday. If by Monday it is not done, I shall call your officer.
Lordship, submission may be recorded, but necessary order may be passed.
That is already recorded. It is a matter.
It was expected because I was not there on that day. They have not served the copy, so I was not there. on that.
Please check up the copy.
I have gone through it. I have gone through it.
It's absolutely clear, Mr. Mishra. It was said that tendency.
My submission may be recorded, Lordship, any order may be passed. Regulation, Lordship,
Why should I entertain your objection, Mr. Mishra? You have not filed any application for recalling this order.
Lordship,
This order stands on its face.
To that extent, Lordship, it is not satisfied one, certified one.
Mr. Mishra, the order, Mishra, it has been stated that department is directed to act in terms of the judgment and he is to file a report before the court.
Lordship,
Electricity-
on Monday, I will file the report.
Yes,
Let it be on Monday, I will file.
but Mr. Mishra, you are,
Feasible, we will provide the electricity.
no, you are our court, you are the officer of the court.
Lordship.
You should not raise, if the private respondent is injured, he should come. That legal notice,
Lordship, we have done our all formalities. We have estimated the cost, everything. Thereafter objection has come. Otherwise, this
so
would have
do
been
we,
provided, Lordship.
so do we record that formalities have been completed and some more time is required for compliance?
Lordship, that is not because it will be. Because they will create problem to me.
Tehsildar demarcated now only for report pendency.
Stop, Leko, you are Mr. Shejian.
Yes, ma'am.
Condition is not complete, okay.
Mr. Mishra,
I used to appear, but I did not receive any. They have not served the department.
electricity,
They have not served the department.
give a copy to Mr.
But
Vishal.
let them serve. Lordship. I have to take instruction. Without copy, it is very difficult.
No, I will,
The tactics of the petitioners, Lordship, they will serve me. Some
oh,
of the cases I found that they have not constructed the building and they have come before this court, they have got there. They are praying for electricity. That is
all
the
right,
difficulty.
Let me put the Monday, okay, I will come.
the learned advocate, Mr. Siddiqui,
Yes, sir.
learned advocate
Off the record, we say one thing.
Yes.
As a lawyer, to get an order is a very toughest thing. And particularly when we are holding the brief with private person. Off the record. Simply and simple. It's a very tough thing.
I am representing the respond number 1 and 2, my lord.
This is for the sixth time and before this court. In the past, license was issued in the name of private respondent. That was court in an appropriate proceeding. Again, the authority did the same mistake. Again issued a license in the name of private respondent in ignorance of relevant materials. The relevant materials would be in terms of the scheme of regularization. Stated 15 July 2003, I'll draw last that scheme at page 76. So can you have a look at page 76 months? Not yesterday, I have literally opened the case. Not can understand much. This is the scheme dated 15 July 2003 at page 76, under which regularization has to be done in connection with excess land held and possessed by pre-1942 settlers. I'm just placing this scheme. I'm claiming the benefit of this scheme. My case was not considered, but the case of the private respondent was considered for the second time, and the license has been issued, which I challenge in the present.
They have been given the license.
Yes, second time. First time also license was given. I approached this court because there were a report of the surveyor which says that I am in possession. In terms of the scheme, one who claims benefit has to show that he or she is having a recorded land. Along with the recorded land, there is an excess land. In terms of this scheme, the excess land has to be regularized. That's the tenure of page 76. And the authority, while holding survey, clearly held that I am in possession. The deputy commissioner have said that's part of the litigation.
Before we go to that, Mr. Jaipal, the appeal court order which was passed, saying that the order has already been implemented, and however, a new cause of action has occurred, and as such, you would be at liberty to challenge. This is that. And in answer to that, you made one submission that your initial writ petition challenging the earlier order which has been implemented is also surviving.
No, that was withdrawn. Pursuant to the leave being granted by the division bench.
Oh, you withdrew it.
To the writ, and I have assailed the order in license in the present writ.
So first you tell me, Mr. Jaipal, when the rudimentary order has evolved the sanctity, whether the consequential order can be interfered with.
That order was simply an order for consideration. There was no, it was simply for consideration.
No, the order dated that is at page 93, 6 December 2018. I think that was the order which was challenged by you, and implementation was sought by the private respondent.
My lord, my lord.
Now you are for the private respondent.
Official respondent, respondent number 1 and 2.
Then who are the private respondents?
Mr. Anando Haldar.
Who?
Mr. Anando Haldar.
Anando Haldar.
Oh, then you inform Mr.
I
Jaipal.
didn't notice, Lord. He was there all through. In the
He was
meeting.
there.
He was there. We both did a matter before the court number 2, a second appeal. He was there. He assured that he would be. Let it pass off for a while. Let me see.
No, you start. Let us see. We can. So this order of page 93 has. What I am asking you is, if this order challenge against this order is no longer subsisting, how can the consequential order survive?
Not based on this order, they have issued the license.
Exactly. So if you don't interfere with the parent order, then the license is a consequential step.
The division bench granted me two-folded liberty.
Come to
Then
that,
you amend the petition.
or you challenge.
Challenge it.
No, but challenge, Mr. Jaipal, your challenge will be that parent order which was 96 page.
Yes.
That order is bad. Because that order went in favor of the private respondents.
Based on this page 96, the impugn license, not the
It
effect.
was granted, was
The
granted.
effect would be, if I could demonstrate that license is bad in law for various reasons, then the entire thing goes wrong. Simply stated, by passing an order, the right has not been crystallized. It's upon issuance of license, the right has been vested to the private respondent. So license is questioned in the present litigation. The very license, simply stated, passing an order will not do.
Please place the license before first. That is at page 109, 108. That is not a typed copy, it is very difficult.
There is a legible copy in their opposition. I'll show that.
I have enclosed page number 22 of opposition
Page 22.
of respondent number 1 and 2.
20.
Now, that was an order for consideration for issuance of license.
Yes, Lieutenant Governor was requested, but rather the Deputy Commissioner relegated the matter to the Lieutenant Governor.
Hmm. Upon arriving at a finding, na.
Not unless, not under the regulation under which.
I am of the page 96, can you come? In view of the aforesaid, I am of the considered opinion. Page 96.
My lord.
I am of the considered opinion that such and such being the descendants are entitled to get the excess land regularized in their name.
My lord.
So my question to you, Mr. Jaipal, is unless this finding is disturbed, unless this finding is set aside, issuance of, however, governor is authority is the competent authority issue license is directed to take up the case for consideration of the honorable governor.
My lord.
So when this finding in the previous paragraph remains, how Mr. Jaipal?
The approving authority is the Lieutenant Governor. It's not tentative in nature. It is provisional in nature. These findings are in provisional. It does not affect the rights of the party. It is only upon issuance of license in terms of local regulation, which are challenged here, the rights is crystallized. It's not tentative, not most. The reports of the Tahsildar, the findings of the Deputy Commissioner, those are provisional in nature.
All right, place the governor's order.
Their opposition, authorities opposition,
Page 20.
page
Yes.
20.
Page 17 is the governor's order.
Or license. Page 22 of legal opposition.
Page 17 is what order? 9 June 2023.
Order of the Lieutenant Governor.
9 June 23.
Yes, my lord.
After this order of 6 December.
My lord.
Oh, then whereas this order is 9 June 23. Appeal court, Mr. Jaipal, show us page 99 first, what was left open.
99. May I read from page 97?
Yes, yes.
Third, this appeal arises out of an order dated 22nd December 22, passed by the Honorable Single Judge in WPA number 92 of 2021. It is submitted by Mr. K.V. Jaipal, Learned Counsel for the appellant, that the appellant had filed WPA number 313 of 2018, in which Shahab Ali and other two respondents, they are the private respondent, the appellant had filed the aforesaid petition with the prayer
It was clear.
order dated 6/12/2018,
18. No.
passed by the Deputy Commissioner South Andaman, in which the recommendation was made for issuance of license in favor of the aforesaid Shahab Ali. The aforesaid Shahab Ali filed petition number WPA number 92 of 2021 in respect of self-same land claim for implementation of order of the recommendation of the Deputy Commissioner, South Andaman District. In the petition filed by Shahab Ali, the petitioner
Was a response.
Both the petitions being related to self-same subject matter and self-same order, it was being heard simultaneously, though not analogously, by the court. It is submitted by Mr. K.V. Jaipal, Learned Counsel for the appellant, that on 22/12/2022 he was absent from the court on the ground of some health issue. In his absence, the Honorable Single Judge passed the interim order directing appropriate authority to implement the order. It was subject matter of challenge in WPA number 313 of 2018, filed by the present appeal. The present appeal has been filed with the prayer to set aside the impugned order passed in WPA number 92 of 2021. Mr. Anando Haldar, Learned Counsel for the respondent number 3 and 3, 4 and 5, submits that the order passed by this court, which was also subject of challenge in WPA number 313 of 2008, has already been implemented on passing the impugned order by the Honorable Single Judge. Mr. Arun S. Kumar, led by Mr. Vijay Pure, Learned Council for the Administration submits that in fact, the impugn order passed by the Honorable Single Judge has already been implemented. Never considered the implementation of the order passed by the Honorable Single Judge has given rise to fresh cause of action so far as present appellant is concerned. If so advised, the present appellant may make necessary amendment in the writ petition WPA 313 of 22 to bring on record the subsequent facts, or he may withdraw the writ petition as it was become infractious with liberty to file the afresh writ petition bringing the new facts on record. However, the choice lies with the appellant. The order of the Deputy Commissioner of South Andaman have already been implemented, so no interim order or any order of injunction or stay can be passed at this stage as the new facts are not before us. However, we dispose of the appeal directing appropriate authority of the respondent to give a copy of the order implementing the impugn order passed by the Honorable Single Judge within a period of 2 weeks, hence appellant or his counsel. So, the division bench carry out amendment, bringing those post-item facts, or you get the writ petition 313/2018 withdrawn, take out a fresh application. This is a fresh application where the license has been challenged. So, the order of the Deputy Commissioner, which my lord have just put a query, my lord, at page 93, this was challenged in my WP 313 of 2018.
Yes,
I withdrew it because Deputy Commissioner simply relegated the matter to the Lieutenant Governor.
After arriving at finding, Mr. Jayapal,
Take not moves, it's a tentative, it's not a conclusive, not moves. Issuing license to be issued upon approval being accorded by the Lieutenant Governor upon application of.
show us what is the wrong.
The license for page 22 of their opposition mechanisms.
Page 17 it starts. I know. What is page 17? This 9 June
It's
23.
about the Lieutenant Governor
Huh.
based on the impugn
License was. So you are challenging 9 June now.
Yes, yes. May I page 17? The Honorable High Court of Calcutta Circuit Bench.
You can skip those two portions. Next,
State
whereas
take Malos to.
whereas in pursuance of the aforesaid order, notice of hearing was issued.
Notice was issued on 30th May 2023 to all concerned, subsequent to which the undersigned held a hearing on 6/6/2023 at 10:30 AM at Rajnivas, in which the following were present. The officers may give us, even my clients, they presented to lawyer, no? And whereas on examination of issue involved, following chronological events related to the matter came to the during 2003, the Government of India approved regularization of scheme for
For the settlers.
exercise in possession of pre-1942 settlers up to the year 1961. The relevant part of the Government of India letter number so
Such and such.
it has been reproduced. But B, Villain Khatani prepared during 1961 records that the tenants Sri Kanayalal and Bijlal, son of Nadalal.
What is Milan Khatuni?
It's a statutory register maintained here, where lordship the factum of occupying a government revenue land is recorded. It's not a record entry and sketch map.
It is a statutory.
Register maintained under the special regulation, that's 66 regulation,
Hmm.
to show that the nature and the name of the encroachers with the area occupied.
But the 66 regulation in respect of pre-42 encroachers.
Yes, because scheme is of 15th July 2003. The scheme is of 15th July 2003.
Yes. Now,
B, lordship, B, at page 18B.
yes.
Villain Khatani prepared during 1961 records that tenants Sri Kanayalan and Bijlal, son of Nadalal, were in occupation of 683 square meter of land instead of its recorded 381 square meter prior to the year 1961. The total area of 683 square meter was provided a provisional survey number 1059, out of which, as per records, 302 square meter has been indicated as the excess area.
Hmm.
After death of Kanayalal, his share was mutated in favor of Radhika Devi. After the death of Bijlal, his share was mutated in favor of Kishoridan and Saraswati Devi with the share of an area of 550 square feet each. After the death of Saraswati Devi, her share was mutated in the name of Renuka Devi and Tarpi Singh. Later on, Sri Kishorlal sold his share to Kushal Haridas to a registered sale deed in the year 1989 Lastly, Renuka Devi and Rajbir Singh also sold their share to land to Srimati Shobha Singh during the year 1989. During the year 2003-2004, a survey team was constituted for excess
Area very.
verification. As per the survey report, Srimati Radhika Devi appears to be the occupant of 302 square meter of excess land. As approved by the then Honorable Lieutenant Governor, an area of 302 square meter was regularized and a license for an area of 302 square meter in survey number 1059/3 was issued in favor of Radhika Devi on 12/11/2013. This was set aside by the court. Previously, the same license was issued in the name of predecessor of the private respondent, Radhika Devi.
Radhika is the predecessor of private.
Yes, that was set aside by the court. I'll show that also.
Now, this license was granted on 12th of
11/11/2013.
Yes.
Agreed by the above mentioned regularization, Srimati Shobha Singh filed a writ petition number 68 of 2014 before the Honorable High Court at Calcutta Circuit Bench at Blair. The Honorable High Court passed an order in the above case on 9/9/2014 stating that this court is satisfied that the petitioner has made out a prima facie case of being unaware of.
So that was on natural
Natural
justice.
justice, absolutely.
Next.
Then X not Sri Shabab Ali and others, but the effect was not the license was set aside. Sri Shabab Ali and others filed writ petition WP 327 of 2016. In this, Deputy Commissioner was directed to decide the matter afresh. In pursuance of the directives of the Honorable High Court, the Deputy Commissioner South Andaman passed an order dated 6/12/2018. Wherein was ordered, complying with the order of the Honorable High Court, the petitioners and the private respondents were issued notices and they appeared before the court for hearing and were heard on various dates and finally on 10/8/2018. In the present case, the administration, after carrying out survey, found that Radhika Devi is in occupation over the excess land measuring 302 square meter at Jangligarh village, originally under the occupation of her father Kanhaiya and recommended for regularization. I am of the considered opinion that the petitioner Shri Shabab Ali Shri Shakir Shabab and Ms. Rubina Shabab, being the descendant of late Radhika Devi, are entitled to get excess land.
So it was in their favor.
Yes, no. And whereas a 3-member committee under the chairmanship of Commissioner cum Secretary Andaman Nicobar Administration, Secretary Revenue and Deputy Commissioner South Andaman, as members have examined the matter in detail with the minutes of meeting held on 4/5/20.
What is the jurisdiction of this 3-member committee?
No, sir, it was
This was done by the Lieutenant Governor. Must be.
the record so no, sir.
That's very good. This was on 4th of May 2023, and the earlier order in their favor was passed on
No, sir, 12/11/2013.
not 12/11/2013 was set aside.
My lord.
Next came the order of 6 December 2018.
Yes, my lord.
Compliance second time license was second time entitled to get regularized, but license was not issued.
Recommendation was made.
Recommendation was made. Now thereafter, it came before a committee.
My lord.
Then what did the committee say?
Page 20, last but one paragraph note, and whereas opposition being heard was accorded to all concerned. Only repeated submissions already made earlier were made by the petitioner.
No, Mr. Jaipal, this committee gave resolution was on 4th May.
2023.
That was also in favor of the private response.
Yes, ma'am.
Now then, opportunity was accorded, only repeated submission already made earlier, now presented. None of the parties presented any material. Matter is disposed of on the basis of the facts already given, now they are. The totality of circumstances.
The totality of facts and circumstances of the case, revenue records and proceeding of the hearing on 6/6/23 have been considered. In confirmation with the approval of the then Honorable Lieutenant Governor, Andaman Nicobar Island in this case, which has been further corroborated by the 3-member committee under the chairmanship of Commissioner cum Secretary Andaman Nicobar Administration, I am of the considered view that Sri Shabab Ali Shakir Shabab and Ms. Rubina Shabab, being the descendant of late Radhika Devi, fulfills the pre-condition of regularization scheme dated 15/7/2023 and are entitled to get excess area regularized in their name. Accordingly, in view of the foregoing, I hereby order that the license under section 146 of Andaman and Nicobar Island Land Reforms Regulation 1966 issued to Sri Shabab Ali, Sri Shakir Shabab, and Ms. Shubina Shabab being the descendants of late Srimati Radhika Devi. This case is thus disposed of. Then the license came to be issued, which is at page 20. This I have changed.
Hmm.
Now, there are sufficient rather relevant material on record where the deputy commissioner has said in the past that the excess land is held and possessed by my client, Shobha Devi. This was ignored while taking decision. The relevant consideration was ignored. Irrelevant consideration was taken. What was the irrelevant consideration? The order of the lieutenant governor granting license previously, which was set aside, be it on any ground, violation of that was taken care of.
So where is that report saying?
Also, Mother, kindly turns to the writ petition, page 90. Page 90. I'll show that. This was not taken care of. No. Page 90, annexure P12. In my writ petition.
This was the earlier order.
Yes. These are the metrics. So this order contains a report of survey held by the authorities. There
So-
can't be two reports.
No, this order was set aside, no? This order is dated 1st July 2010. First, it will be first, what is the date of this order?
It's dated is at page 92, 1st July 2016.
It's 1st July 20. It is a proceeding under which provision?
Indeed, this was the deputy commissioner took up the matter based on a direction of the
High
report
Court.
passed on 2/6/2016. Page 90 may kindly be seen. I'll show that order now. 2/6. 2/6 at page 84 of the repetition by a single judge.
This is at the instance of the private response. Radhika,
Yes.
this is page 80 you said.
Page 90 is the order of the deputy commissioner.
2nd of June order?
Is of page 84. Page 84.
Hmm.
Now to see page 84.
Hmm.
I'll just take note of that. Simpliciter, the matter was relegated to the authority without deciding anything on merit. I'll show that part. But page 88, second paragraph, in my opinion. Page 88, second paragraph. In my opinion, however, in the factual context of this case, the decision of the deputy commissioner to issue license cannot be held to be conclusive decision on its part, as the deputy commissioner himself did not get the opportunity to adjudicate on the list involved among the parties. He had acted on the recommendation of authority, whose jurisdiction to decide the dispute of this nature has been found to be lacking by the court in the judgment delivered in WPA number 69 of 2013. There is no material on record to the effect that the deputy commissioner had applied his mind in the capacity of an adjudicating authority while issuing the license. In such circumstances, I do not find any reason to interfere with the order of the assistant commissioner. The impugned order does not adjudicate on or determine rights of the parties in any manner. The assistant commissioner in his order dated 12 December 2014 has only given the ruling on his own jurisdiction to decide and the dispute and held that he lacks such jurisdiction. Let the dispute be examined afresh by the deputy commissioner. South Andaman, upon giving opposition of hearing to the petitioner and the private respondent, in course of such hearing, the party shall be entitled to lead evidence. The available records shall also be considered by the deputy commissioner. Such decision may be taken within a period of 8 weeks from the date of communication of this order, but status quo as regards occupation of subject land shall be continued until the issue is finally decided. I make it clear that I have not addressed any of the issue raised in the writ petition on merit, and the deputy commissioner South Andaman shall address the issue on merit for adjudicating the dispute. Then the order at page 90 came to be passed by the deputy commissioner, upon which I place reliance. So this is the sheet anchor for the writ petition.
That has been set aside, my lord.
Hmm. This order that page, this order was in your favor. Page 90?
Yes, yes. But Manoj, what the deputy commissioner has said, I'll show that. The deputy commissioner has recorded, kindly comes to page 91, what the deputy commissioner has said, page 91.
Yes.
At the top, Manoj, the case of the petitioner, at the top, that paragraph. Petitioner in this proceeding was Radhika Devi. The request of the petitioner is to consider the case for regularization in respect of excess land measuring 302 square meter in survey number 195 of the peak, corresponding to provisional survey number 1059 of the peak situated in Chandigarh. Discussion. The entire issue is regularization of 302 square meter excess land as per Milan Khatami recorded exhibit 1. It is pertinent to mention here that there were two co-tenants, Sri Kanaila and Bishlal, son of Nadala. The government of India approved this scheme of regularization of excess land in possession of Sri 1942 sector up to 61. The main condition approved by the government of India, white letter number so-and-so dated 15/6/2003 is reproduced as under. The scheme has been produced. No, thereafter, in pursuance, not good point. Immediately after the reproduction part,
Yes.
in pursuance of the above scheme, survey was carried out. And on the provisional record, survey number 1059, the possession status was captured, exhibit 6. From the exhibit 6, it is clear that Srimati Radhika Devi, Srimati Shobha Singh, my client, and Srimati Ushara Haridas were shown in combined possession of 302.
Very good.
So, if at all license could have been issued, it could have been issued along in the favor of my client also. But that has not been done by the Lieutenant Governor because
This order no longer is there, Mr. Jaipal. This order has subsequently been set aside by the
it was
court,
set aside with the
by the order of 6 December.
6 December. But 6 December order says, Marshal, in terms of
Now, ultimately, what was the decision? License issued on such and such in favor of is not correct regarding. So, these license earlier issued in case of
Radhika Devi.
Radhika after producing
Not
record,
a no.
but in this, one of the
Regarding the
tenants.
name of Shobha Devi and Sriyadasi, that their land is illegal occupied, they are advised to approach appropriate authority. Please follow.
One of the court has sold out, therefore entered 30 which was under possession of co-tenants. After producing the records of consideration, excess land to be regularized was meant for all co-tenants,
Yes, including my client.
including who have maintained corner. But in the instant case, one of the co-tenant has sold out the allotted plot. Therefore, the entire 302 which was under possession of both co-tenants in 9 cannot be regularized in the name of one co-tenant.
That's Radhika Devi. Therefore, the license dated.
Now, who sold out? Radhika sold out.
Radhika sold out. So only the court said that it can't be done in the sole name, it has to be in the name of all tenants.
Therefore, the license issued on 12 December 2013.
It's not correct.
Oh. This year 2013. Now, this has been set aside.
Set aside with the rider lordship, the deputy commissioner has to consider in the line of direction passed by his lordship.
So, this was challenged.
Anindam Sinha, same order, in terms of Justice Anindam Sinha order, the first consideration has to be made. Then 16/12/2018 order came to be passed.
Right.
Yeah.
Now, 6 December 20.
6 December 2018, my lord.
In that order was held in your against.
Against, but the report was not taken into account.
Which report?
The one which has been relied by the deputy commissioner at page 91, exhibit 3, which shows that I am also maintained the possession. Page 91, my lord, again reading from exhibit 3, immediately after the reproduction part. From exhibit 3, it is clear that Srimati Radhika Devi, that's the private respondent's predecessor, Shobha Singh, my client, present lead petitioner, and Srimati Ushara were shown in combined possession of 302. But the scheme of regularization is that one has to maintain continuous possession. That's the sine qua non. I have to be possessing excess land along with my recorded land. One has to maintain a continuous possession. It is ascertained from a survey being done, which was recorded as exhibit 3.
Now, please kindly come to page 95.
95.
That was, will you explain this paragraph? Repair theatre and whereas.
In compliance of the order passed by the Honorable High Court of Calcutta, called for reports and scrutinized the affidavit opposition filed by Sri Santosh Prakash.
Who scrutinized? This is the, in compliance of all the, who is the Santosh Prakash?
He was one who affirmed an affidavit as an assistant commissioner settlement in one of the proceedings.
narrated the stand taken by the administrator. He categorically stated in para QR of this opposition that Shobha, under the pretext of clearance of her approach path, apparently has the ulterior motive of claiming the excess area and order of joint as is held, as she is having an occupation over them, whereas the fact remains the petitioner's predecessor in interest was in occupation of the subject, and after his death by the petitioners maintained all this. Who was the petitioner here? This is Probapati.
The predecessor of Radhika Devi, Shababali and others, private respondent in the present proceeding. Shababali.
So this was the finding. Moreover, in pre-61 survey report, as reported, Blair clearly shows the Shobha that neither Shobha nor Smita have any portion over such land. This is
No, but there are two reports. To turn down my claim, my report could have been considered in one or other way. There's no consideration. That's what I'm saying. There is already Deputy Commissioner saying that Exhibit 3, I am maintaining continuous possession along with Radhika. Why that was not considered, not by taking decision. It is adversely affecting my interest. The same author, how can that be lawsuit? They party cannot blow hot and cold at the same time.
authority have used in the opposition.
Yes, no.
Yes.
They use your position. You take it in the same lawsuit, but consideration has to be made in one other way to reject it. But there has to be an application of mind. So far as the report which has been relied at page page 91, that is, because the Deputy Commissioner was acting in terms of the direction of order passed by His Lordship Honorable Justice Anand Sinha.
Now you are Shobha Singh.
Yes, ma'am.
Shobha Singh, your predecessor in interest was who? Who was your predecessor in interest?
No, no, Sobha Singh has purchased it.
No, that two tenants na, Kanai Lal and how did it devolve?
I'm connected with Kanai Lal, Lord.
Come to page 18, this Milan Khatuni,
180.
18, in their opposition. Kanai Lal, prepared during 61 records, Kanai Lal and Brijlal were the tenants. Got it? Page 18. 683 instead of his recorded 381 prior to it. The total 683 was provided and provisional, out of which 302 has been indicated at excess.
Yes, that's it.
Now after Kanai, his share was mutated in the name of Radhika.
No.
After the death of Brijlal, his share was mutated in favor of Kishori Lal and Saraswati, with share of an area of 550 square feet each. How this comes 550? 550 is the total area was 683.
Yes.
Now if each is to hold 550, then it comes to 1100. 1100 feet, but there it is square meter. After death of Saraswati, her share mutated in favor of Renuka and Rajbir. Later, Kishori Lal sold his share to, how can,
Usha Haridas.
Kishori Lal sold it to Usha, and Renuka and Rajbir sold it to Shobha.
Shobha.
So your argument is the license could not have been granted exclusively to.
Yes, my lord.
This is.
I am also entitled. Report says so, not. If they want not to exclude include me in the license, there has to be consideration with regard to page 91, the report, survey report, which I have referred to in my writ petition, where it has been categorically said, I am also maintaining possession. Scheme is, it's a requirement of scheme. One has to maintain.
Achha, where is this order of page 95 of your writ petition? This order of 19th November 2007.
Page 95 of the report.
Of your writ petition, page 95, that portion which you are reading, Santosh Prakash affidavit,
Page 95.
3 lines from the bottom. Moreover, in pre-61 survey report of survey,
My lord.
and settle as well as report of Tehsildar date 19/11/2007. Where is this order? Which clearly shows that Shobha, neither Shobha nor Usha. Now, Usha is the person who got from Kishori Lal.
Kishori Lal.
So why do they say neither Shobha nor Usha have any portion of land in 105?
But their own report at page 91, again at the cost of repetition, I say much. Their own report says survey was conducted, is being done to ascertain the ground realities. So only one can come to a conclusion that who maintained the possession. When the deputy commissioner who in hierarchy is above than the assistant commissioner, Santosh Prakash, have already opined at page 91 that Shobha along with Radhika maintained the possession. At best, Lordship, joint license, you want to exclude me, exclude it, consider it.
Do you have this letter of 19th November 2007?
Not kind of appreciate one thing more. Scheme is of 2003. Not to see the scheme, the survey has to be conducted afresh, not based on old records. Everything was done. Let's go to the situation that the report which records my possession has been ignored. But the report based on which the license was given, those are old records. Scheme says 2000, it is a prospective effect. Scheme has come in the year 2003. Survey has to be done either in the year 2003, 2004, 2005.
No, 2003, your exhibit 3, where is that exhibit 3?
Not exhibit 3x, but the recording is there, not page 91. It clearly depicts.
Yes, Mr. Shivalan, you produced the exhibit.
Report of the Tahsildar, my lord.
Yes, sir. Page 91. Page 91 of my petition.
I do not, your argument is as per exhibit 3, both Radhika as well as Shobha together with one Usha.
Yes.
Usha are entitled to be in possession of the same.
Yes.
Were in possession of the same.
Yes.
So if such possession was there, then license in terms of the scheme would have been granted to the actual possessors,
Yes, ma'am.
which
Yes.
includes your client.
That's my case. That's my case. How this was ignored? But they are free to ignore it. But there has to be some consideration, so far as exhibit 3 is concerned, that this can't be acted upon for reasons known to law. They bring some other report, they discard my claim, I've been excluded as a licensee. And particularly when there are series of proceeding orders of this court, directing the deputy commissioners time and again, take a decision, conduct a survey.
That makes it go against you. Why sitting in judicial review, we shall delve so deep into the
The
matter.
decision-making process is challenged. It's an arbitrary. I'm not challenging the decision. The decision-making process is arbitrary. Relevant consideration has not been made. Irrelevant consideration was taken care of by taking decision.
Kanai's share was mutated in favor of Radhika. And breach went to Kishori and Saraswati. After Saraswati came to Renuka and Rajbir. And from Renuka and Rajbir, you came into light in 1989. You have not found this order of 19 November?
But
So, Mr. Shivalan,
My lord.
what is your contention? It
Lord,
is a very narrow
the order
point.
of the lieutenant governor.
Uh-huh.
The order of the lieutenant governor is has been made after considering all the records is correct.
No, where is that he has recorded? Because what is your answer to his argument? That your own records show that as per the exhibit, I am not the total possessor, but I am one of the possessors. So license can be given. My right does not go away. This is his contention.
And my one more submission is that he is not, petitioner is not the descendant of the original allottee. They are the purchaser. Whereas the private respondent is the descendant of the original allottee.
this finding has not been arrived at by the lieutenant governor. He can't supplement what is not on record.
So you mean to say that only a descendant, only if he is a descendant and he is a possessor, then only the claim will come?
Yes, ma'am.
Your scheme does not say so. Your scheme is restricted to the possessors. Regularization of excess land has been considered. This excess land which possession as identified in silence might be regularized without area. The regular is subject to following conditions. Regularized only to the extent that the concerned occupants have maintained their continued concerned occupants and their descendants. So if you say that he does not come within the purview of this scheme, you could have rejected his claim on that. The 2003 scheme does not bring him within consideration.
What the scheme says, my lord.
Please produce this Tehsildar report of 2007.
I shall call for them. Yes, I will. I shall produce.
Then I cannot dispose it of.
The Tahsildar is the next door. Tahsildar portal is the next door to the court. They can be given 2 days time, it can be procured, not records are next door.
We have, this court has heard Mr. Joypal explain, learned advocate.
It's BSNL matter.
Termination of
Termination.
suppression of pending criminal case.
Oh, yes, yes.
So, Your Lordship, just not today, Your Lordship. I had called them yesterday, but they didn't come. So today, Your Lordship, I'll take instructions and we can finish up the matter tomorrow.
Not today. Yes.
Item number 10. PA 1072 of 2023.
This is your timber.
No, tender matter is there, that can be disposed
Yes,
of.
Your Lordship. I have got the instructions.
আচ্ছা তাহলে
That
Mr. Dwivedi, please, you are doing, just let me take up that.
Item number four.
Item number,
Well,
আচ্ছা,
12.
no, no.
WPA 9.
Wait, I have to go see the record, what is. Oh, Mr. Dwivedi, you are also there in this matter.
Yes.
Oh,
Last Sunday.
okay, please tell me, please just remind me what is this?
My lord, a tender notice was published by them on 9th of October 2020
Then is by
by
the.
the Indian Oil Corporation.
Acha.
That is at.
Then they don't have any substantial.
Because they are the Rajya Sainik Board, my lord. Who gives
Acha,
the
acha.
name of the,
Acha, acha, you tell us what, how can I dispose of, let us
My
understand.
lord, my lord. A tender was floated, my lord, on 9th October 2023 by the Indian Oil Corporation for supply of security service.
9th October 2023.
2023. And the condition was that in this same, they say that the rates are fixed and they say that the service charge ought to be 10%. Not less than 10%, not more than 10%.
No, please explain that to me. This is a tender.
Tender.
Who will, who
Tender.
will participate? The,
Only the ex-servicemen
acha, who have been sponsored?
enrolled by the Rajya Sainik Board. Rajya Sainik Board.
Rajya Sainik Board
Sainik Board.
sponsored agencies.
Yes, but they will give a list that these are the persons who are enlisted.
Who are you? You are,
I am one of the expert,
You are the-
ex-servicemen, my lord.
you are the firm.
Firm.
Acha, this firm is registered and is coming within the list of the Sainik Board.
Sainik Board, because we are
Ex-servicemen.
servicemen.
Acha, very good. Then you participated in the
I
tender.
participated in the tender.
Hmm.
In tender, the
Hmm.
rates for supply is fixed and the service charges are also fixed. That is 10%. Nor less than 10%, nor more than 10%. Page 30, my lord will get it.
Page 30.
30, 30. Of the tender notice.
Yes,
Now, my lord, can you see
clause,
clause 10, subclause 4.
clause 10, that is in page 30. Now,
My lord, amended writ petition, my lord.
এই কোনটা amended হয়েছে দাও।
Amended writ petition.
ও আচ্ছা আচ্ছা আচ্ছা। No, this is opposition.
Yes.
এই মনোজ, একটু sharpen করে দিয়েছি। Yes, page 30.
My
Yes.
lord, let's see page 29 first, my lord.
Yes.
29 and 30 I will place. 29, clause 4, my lord.
Yes, clause. Estimate.
Rates are fixed, my lord. For for that is 1 year, 86 lakhs 59,000. That is fixed. Plus 18% GST. If it is for 3 years, the rate is 2 crore 59 lakh and with 18% GST.
Hmm.
Now, my lord, may kindly come to clause page number 30.
So upon being selected, you will be paid rupees 8,50,000 for the services of 1 year. That is the.
Yes, my lord.
And rupees such and such for services for 3 years.
3 years.
Now this was for 3 years or 1 year?
This was for 3 years.
This was for 3
3
years.
years.
Very good.
Now,
And
kindly-
and you have to pay a service charge.
Yes, of 10%. Not less than 10%, not more than 10%.
And this next previous clause in the eventuality
Yes.
of all the.
All the Rajya Sainik Board sponsor, yes, quoted the same rate.
Hmm.
The contract under consideration will be allotted to the senior most sponsor.
So there cannot be two different rates.
That's what I am saying. There cannot be. There cannot be.
Estimated cost.
Acha, she will make out a difference. All
No, my
right.
lord, there cannot be. That's why I have filed this writ petition. There cannot be. That's why, my lord, I say that the moment clause 4 and clause 3 is read together, only an incumbent who is senior, he will always get that. Now, in their reply, after this, my lord, may kindly see their reply at page number 9, last 2 lines.
No, sir, if it is a fixed price, question of tender does not apply.
Yes, it's a fixed rate. That's why I say it's arbitrary.
It is an estimated rate.
No, my lord, may kindly see page 9 once of their reply, and I will show one document.
No.
That's why, my lord, that is my
Yeah,
case.
yeah, yeah.
That is my case, my lord. My lord, may kindly come to page 9. last two.
They must have said somewhere that
No,
it
no,
is
my lord,
estimated.
my lord, can you see last two lines? And I will show one document.
By a letter 10th of November clarified,
That the
gave a
seniority
clarification that the seniority list henceforth
will be
on rotational
basis
basis.
for each first tender. Now, my lord, can you see this document is also annexed, page 87. Page 87, my lord, by the Rajya Sainik Board.
That is page 87 of.
87 of my writ petition.
Yes, you can read it. I cannot.
My lord, I will just read the related provision. Clause 3 says, regarding point number 2 of your letter dated so and so, whereby the seniority to be observed for this tender is already given out, the seniority list from henceforth is on rotation basis for each fresh tender.
For each fresh.
Tender. So, my lord, this is my case. Why I approach this court? I have no case why I should approach this court. The case is that everything was fixed. The person who is senior, he will get it. My name appears at serial number 4. At no point of time I will be getting any tender. So now they say, when they found that there is a litigation.
Now, where is this regarding point number 2 of your letter? This is a clarification given by the secretary of the Sainik Board to the plant manager of IOCL.
My lord.
No, this is vague.
At present, they are not claiming that that particular tender has to be.
Given to them.
In future, in also they want that this should be implemented. That is only the thing what I feel.
But in future, this implementation is on the part of the Sainik Board, not obligatory upon you.
It's a letter written to us that.
So, suppose tomorrow, if you float a tender inviting from Sainik Board, it is incumbent upon them not to consider the first one who has been earlier given.
No,
On rotational basis, it will appear.
Tender is opened by IOC.
No, my lord, tender is opened by them. They only furnish a list, my lord. So if a tender is allotted, suppose today the first person has got, the senior has got it. When next tender will come,
you will follow the list which will be forwarded.
Yes. My client, I have taken instructions from him. He says that we will be following this particular letter.
In respect of future tender.
Yes.
Yes, in respect of future tender. Unless revoked by Rajya Sainik. You know, there is a Rajya Sainik Board. And unless revoked.
My lord, actually, my client is very unlucky, my lord. When they approach, we did not able to get communication and all. That's why we did not got an entry also, my lord.
When Rajya Sainik Board will change their decision. So till the time it is operative, we also will follow. That only I can say. My client has given me instructions in that manner. What can I say?
Now, this tender was floated on 9th October 23.
My lord, page
Now,
27.
who got engaged? Who got his
Private respondent.
he's there, private.
Yes, he's there.
So he was for 3 years.
Yes, it's continuing.
Oh, it is continuing.
The continues, there's a power provision for continuation.
Huh?
In the tender, there's a provision for continuation of until 3 years. The
That is
maximum
what is showed.
that is in the tender only.
It is more than the 1 year, so definitely it is more than.
Yes.
So we can record that he is operating now.
Yes.
And my lord, the seniority list is there, wherein my name appears as serial number 4, his name is appearing in serial number 1. Page
So.
Yes, my lord. My lord, may kindly see page 82. 19th April 2022.
82.
82, my lord. It starts from page 82. Relevant would be page 84.
And the person who has been given?
1. This is 2022, my lord. Now, my lord, I will show 2023. This is during the year April 2022, this list. Now, my lord, we find page 85. This is October 2023. One more list. Here also I am 4, he is 1. So he will always get 1. And I will not get standard.
No, on rotational basis it doesn't.
No, but my lord, when I filed this, there was no scope of rotation. They have next page 86. My lord will find. that he is senior, he will always remain senior.
That was not the decision of the IOC, that was the decision of the Rajya Seni Court. They wanted it should be on seniority basis.
My
we
lord,
followed it.
IOC
Now they are
has
saying that
committed, IOC is fault, my lord, where the IOC has fixed everything.
Ashok, the present writ petition was preferred, primarily praying for
Right.
अच्छा उसमें एक लास्ट क्लॉज ऐड करी इन व्यू ऑफ सच and as it has been agreed and what is the subject matter?
Subject matter is that, my lord, I am a bachelor engineer in electrical and electronics.
Hmm.
A selection process was initiated by the Port Blair Municipal Council way back in the year 2013
Hmm.
for appointment to the post of junior engineer. In terms of the recruitment rule governing the affair, and the recruitment rule says, my lord, that the appointment ought to be made from the having a person having a degree or diploma in mechanical, electrical, automobile engineering from a recognized university. On the basis of that, the selection process was conducted. I participated and I was appointed to the post of junior engineer. Appointed in the year 2013.
Then what happened?
After my appointment, the next promotional channel is assistant engineer, E&L. As for the purpose of having essential length of service is 5 years to be considered for promotion to this head. I completed 5 years of service in 2018. At that point of time, the post was not vacant. So therefore, there is no scope to accommodate me. My lord, in the year 2019, perhaps in the month of May, my lord.
After 5 years. Now,
After 5 years.
so you fulfill the qualification for promotion. Very good. Then
I qualified in 2018. 31st of May 2019, the post remained vacant because a person was superannuated from the said post. Assistant engineer. So, my lord, thereafter the process was initiated and mooted by the department to conduct a DPC. I am the senior most and I have outstanding performance and all, my lord. File was mooted ultimately, my lord, on 7th April 2021. DPC, the committee has arrived to a finding that I could be considered for promotion to the said post.
In the existing vacancy.
Yes.
Yes, then what happened?
Thereafter, my lord, so this is in 2021. Thereafter, the file was mooted to the administration. This is an autonomous body not required. Now, my lord, thereafter, when the file was mooted, a query was made saying that this person was a bachelor engineer in electrical and electronic. Therefore, whether he can be promoted or not, they seek for a clarification. And this run for years together.
No. What was your qualification?
I was bachelor. I am having a bachelor degree
In
electrical and electronic.
Electrical and electronic.
Yes.
Very good.
Now,
And they want a clarification as to whether
I can be accommodated for the promotion post or not. Having a
just a moment. You have a bachelor's in electrical and electronic. And what is the required qualification? Promotion?
Promotion, my lord, they say promotion from amongst the regulars having 5 years of regular service in the grade, possessing degree, diploma in mechanical, electrical, automobile engineering.
Oh, mechanical, electrical,
automobile.
Very
respectively,
from
a recognized university or institution or equivalent.
Institution or
equivalent.
So this clarification was sought for.
This clarification was sought for by the administration. DPC was constituted, DPC recommended, thereafter they seek
Hmm.
for clarification.
Hmm.
Now, in clarification, the administration say that we need to amend the recruitment rule. And after amendment, we will consider. For that last 4 years, this file is lingering on. I have got from RTI all the documents.
No, no, need to amend the rules. Why?
No, because there was a matter of Stanley James, that is, there is a writ petition 5.1 Stanley James. He is also eligible for promotion. There are 3% who are eligible for promotion. One is this petitioner, one is Stanley James, and another person. Stanley James is junior to this petitioner.
Hmm.
But he asked for promotion, he asked for the recruitment of for the amendment of the recruitment rule. Since his contention is the recruitment rules are not from long time has not been amended.
No. His contention was that he was a diploma where the length of service is 9 or 10 years. He want to curtail that down. That has got nothing to do with me.
Thereafter, court has directed us to amend the recruitment rules.
Court has directed
Court directed us to
on
amend
the basis of his
his
representation.
representations and all.
Huh.
So, we are in the process of amending the recruitment.
That is
It sent from DPC, it sends to the departments, and ultimately at page number 53 of our opposition, we see that the law department has said that first you prioritize this amendment of recruitment, and thereafter you conduct the DPC.
DPC has already been conducted.
No, there is a second DPC. In first DPC,
Where is that written?
I know that is all subsequent event which my learned friend is
Hmm.
saying. That has got nothing to do with my case.
No, Mr. Dwivedi, what is your stand that suppose a person, how can it be kept at bay? Then you consider even say that you do not fulfill the qualification, finished.
No, he fulfills the
So now now, Mr. Dwivedi, in anticipation of an amendment, can the person be deprived of consideration for promotion?
But I thought it should not be, but
It cannot be because consideration for promotion is a fundamental right.
and then this law department has given this view, we are this stuff.
No.
That
One more thing is there.
But that is the only submission we got in this matter.
Earlier, my lord, same issue cropped up in the year 2017. In the year 2017, my lord.
What was your prayer in the writ petition? Grant me promotion. Yes.
Considering the grant of promotion, that can be.
My lord, my prayer is, my lord.
No, we will say that they will be considering your prayer for promotion unhindered by the present process which is going on for amendment of the rules. As per the present rules.
This clarification which they have sought for. In the year 2017, the same clarification they have sought for. Administration and the expert body of the administration arrived to the finding that it is equivalent. That also I have enclosed.
Oh, that you.
Finding to that regard by the same administration, same expert body.
Acha, show us. Show us.
Yes.
Let us.
The process has to be completed.
Process is completed, my lord. My lord, a DPC is, I am just giving an example. If a DPC is conducted under the chairmanship of the UPSC, my lord, once they give a recommendation by the UPSC, my lord, thereafter the authorities did not have a say to that.
No, but
Here also.
We will say that they will consider your case for promotion on the basis.
In terms of the recommendation by the DPC.
No.
Already the
Yes.
recommendation is there, my lord.
Yes, in terms of and your claim cannot be rejected on the ground that they are taking steps for amendment of the rules. And that we will make within a stipulated
Yes,
period.
and one more thing, my lord, this issue, if my lord permit me, either today or tomorrow, it may be kept at the top, because I will place those paragraphs, my lord.
That's very good. Only come tomorrow, first matter.
I will just place, because my lord will get the tools, my lord, because already everything.
No, please
done.
please point it out, please point it out. We will, then arguments completed, we will pass the order.
At the top.
No,
but I will place my lords, all the documents so that my lord can.
Very good, we will keep it. Acha, any other matter where both sides are ready?
My lord, one matter is there, my lord, it can be upgraded tomorrow, my lord, with Dwivedi only, my lord.
Yes, yes.
Very short matter, my lord, this.
Yes, another matter was Mr. You mentioned just now.
My, this
No.
item number is
Matter 27, my lord.
আচ্ছা আচ্ছা এই 10 এখন কি 10 নম্বরটা করেছো? আচ্ছা 10-এরটা হলো। এই 10-এরটা কালকে টপে থাকবে। মানে মোশন কিছু থাকলে তারপরটা দেবে।
Saying that there is no industrial dispute. He approached this honorable court. This honorable court passed an order saying that they are workmen, there exists an industrial dispute, you refer the matter within such period or the court has framed the reference and said that it will be deemed that this would be the reference. My lord, despite of that, they did not refer, they rejected it. When
Who rejected it?
the authorities, the Andaman Nicobar administration, court said you pass a speaking order within 2 weeks. If you are not passing, this would be the reference, which would be sent to the labor court. Within 2 weeks, they rejected my case for reference. Once again, I challenged before this court. This court said nothing doing. You have to refer it because it, primarily we are satisfied that there exists an industrial dispute. Now the court has framed the reference. Despite of that, my lord,
The earlier court also framed.
Earlier court framed, but there was a rider actually. That framing was with a rider.
Now it has been reframed.
Reframed by the another appointed bench.
Yes.
Now, after that, my lord, they referred the matter, but the reference which was actually made, whether they are entitled or not, that was not there. They say that as a contract employee, whether they are entitled for that. It acts completely departure to both the orders part by the writ court.
But we research that they are outsourced.
No, that cannot be in terms of both the orders of the court. I will place only both.
So now the tribunal has not embarked upon it.
No, because the moment it was referred, we challenged it. We
So
said
that Mr. Kumar needs clarification through the affidavits.
affidavit is completed, my lord.
No, Mr.
Affidavit has got nothing to say, my lord.
They are working on
Dear, huh?
Their affidavit is of not much concern. I have received, I will not use any reply because my grievances is against the Andaman.
What do you want from us then? Today we cannot change the reference point which has been given. You are saying that what they have sent is violative of the reference point which has been fixed by this court.
Violative of the reference point and the issue which involves between the parties.
So that for that a content was necessary. Why did you come with a fresh writ petition?
No, my lord.
Now, once you come with a fresh writ petition, we have to go into the details now.
Then in that case, my lord.
You give a reply because don't shake away your stand because this point you will be facing that it is not a case that for contempt was not filed within the time, maybe something else. So after that period was over, you had no other option to come with a fresh writ. You could have got the matter settled.
Then I will be using this.
Let it be there in the list as it is. Very good. Chalo dekho. কালকে কোনটা থাকলো আমাকে একটু উপরে দিলাম।
Item number 11 can be updated. This is that matter that this person has retired.
Yes, my lord. I am appealing for the private.
Paragraph 11.
Yesterday we have informed the landlord lawyer who is appealing.
Now you are for whom?
Private respondent, my lord. This is that matter. I was the director ICMR.
Oh, you have retired.
I retired.
To give a notice tomorrow, 11 নম্বরটাকে উপরে করে দেবে। প্রথমে তাহলে থাকবে কোনটা? ওটা তো উইথড্রয়াল, ওটা বেশিক্ষণ নেবে না। হ্যাঁ ঠিক আছে, ওইটা করে দেবে। তারপরে এই মিস্টার কুমারের এই মামলাটা রেখে দেবে, যেটা এতক্ষণ হলো আর কি, কোয়ালিফিকেশন। আর থার্ড ম্যাটারটা রেখে দিও, ওই আইটেম নাম্বার 11 তো থাকবে।
That is already there in the list. So, no issue.
13 is what, mister?
My lord, it is a matter, my lord, there are two matters, for one, Miss Minnie is appearing.
Yes, what is that? Where is she? She was here.
See, my lord, what she has filed, that is the subject matter of a civil dispute before the trial court, that I will argue.
What is the issue?
Issue, my lord, issue is that she says that I am carrying construction in a property which belongs to her and the same is an illegal construction. She claims her right on the basis of a will. That will is the subject matter of a civil suit filed by me before the trial court. Now, in the civil suit, they filed an application for injunction. Being the defendant, they filed.
All right, it is all.
My case. I will submit.
Yes, yes. Everybody submits everybody's case. Okay, it is.
Different activity.
That's a very good. It is already at the top.
Yes.
And who is this 12? Who is appearing? You're again Gopal Bidnu. You're appearing.
This was posted, that contract matter.
12 disposed of.
Contract matter, my lord, that
Oh,
letter.
ঠিক আছে. All right. In one matter, public prosecutor was waiting. Which matter? Any matter was there?
One matter is item number
Mrs.
26 is against me.
20?
It's a promotion matter, my lord.
That is item number
26.
26.
Right.
That is a promotion matter filed by her.
Myself, I have filed it, my lord. She is the respondent.
She is the
This is
respondent.
against the Airport Authority of India,
Promotion.
promotion. I have not been accorded promotion in time, whereas.
Achha, all right, you can this affidavit complete?
Complete, my lord. It may be taken up day after tomorrow, I will inform her. If some priority is given.
No, I don't know. She was here, but whether she is agreeable to upgradation, I
It is
don't know.
agreeable, my lord. This is my petition, my lord.
She is agreeable.
Yes, my lord.
You're sure?
Absolutely, absolutely, my lord.
Or is she there or she has left?
Yes, sir.
Yes.
Yes, sir.
Please agree.
Huh?
Forward.
Tomorrow? Then এই 26 টাকে উপরে করে দিও। ওই after
My lord,
item.
My request is day after tomorrow. If my lord is upgrading it, because there are many things in this matter. It will take some time, day after tomorrow. If it is upgraded, it can be upgraded. Yes.
All right, day after tomorrow. No, it is a very big matter or what?
Big matter. My lord, I want to do because my client is going to be retired by 30th of this month.
Yes.